All right, good morning. This is the Colorado Oil and Gas Conservation Commission. It is August 3rd, 9 a.m. This is our weekly Wednesday business agenda. We will start with the roll call of commissioners.
Thank you, Mr. Chair. Commissioner Ackerman.
Present.
Commissioner Bogue.
Here.
Commissioner Cross.
Present.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Oath.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 7 out of 7 commissioners present.
Fantastic. Welcome to a full quorum. Great to have everybody with us. For our stakeholders, I want to recognize Commissioner Oath. She is now the Director of Environmental Programs. I'm probably botching that over at CDPHE. We welcome her. Tricia will represent CDPHE as the new Director of Environmental Health and Protection for the Colorado Department of Health and Environment. On the commission, she serves as an ex officio non-voting member. By way of a bit of background, Tricia has a long and impressive history at CDPHE with experience in environmental policy, including environmental justice, and has served in roles with Water Quality Commission, Air Pollution Control, and Water Quality Control, and more. Tricia will be leading CDPHE's initiatives to reduce greenhouse gas emissions, improve air quality, protect Colorado's waterways, ensure proper management and disposal of hazardous materials and waste, promote sustainability, increase our understanding of contaminants and health outcomes. Wow, that's a lot. The partnership, we are pleased to have Tricia with us. Partnership between CDPHE and COGCC and our staff is strong and critical to the success in all that we do in our work and to protect public health, safety, welfare, wildlife, and the environment for all of Colorado. Commissioner Oath, we welcome you here and look forward to working with you.
Thank you so much, Commissioner Robbins. I appreciate it. Looking forward to working with all of you as well.
So I stole thunder on commissioner comments with that introduction. Does anybody else have commissioner comments? That's where we are now. Hard to beat that. So we will move to consent agenda. We have one matter. Does anybody have questions on consent? Seeing none, do we have a motion to approve consent?
So moved.
Second.
Motion and a second. Are there questions or thoughts or concerns? Seeing none, all those in favor of consent signify by saying aye.
Aye.
Aye. Consent passes. Moving right along, we have a short permitting update and staff report from Sabrina Trask, our permitting manager. Hearings manager, do we have Ms. Trask? Oh, I see she's coming. Good morning, Ms. Trask.
Good morning, commissioners. Good morning, everybody. I do have just a couple of short slides. I just did send them to Mimi Larson and I think Angelica. Were you able to get those slides? I apologize for the late email. I was wondering if you could share those.
Oh, okay. You need us to share them? Sure. Give us a second.
Thank you.
Okay.
Here we go.
Awesome. Thank you so much. If you want to just jump to the next slide. I just have a couple of quick statistics from the planning and permitting unit that I wanted to walk through. And this is not comprehensive to all forms that the planning and permitting unit processes. This is only for permit forms, so OGDPs and Form 2s or applications for permit to drill well permits. So for the year to date, so from January 1st through yesterday, the commission has approved 22 OGDPs. This does not include OGDPs that were approved in 2021. Within those 22 OGDPs, there were a total of 36 oil and gas locations. That includes both brand new locations as well as excuse me, amended or existing locations. I do want to just highlight that some of the OGDPs that have been approved have had new locations, have had existing locations that were expanded, and also had the inclusion of some existing locations that were only pulled into the OGDP because of the mineral development. So no new activity actually occurred on some of those locations. There were 19 new locations out of the 36. 19 of those locations were brand new. And of those 22 OGDPs that were approved, that included the approval of 415 total well slots. This is a little bit of a strange term that I'm using here. It includes both new wells and existing wells. And let me just take a moment to say what a well slot is. It's not a defined term in our 100 series. It's basically the number of wells that are approved on a given location, the maximum well count that is approved on the Form 2A. It doesn't mean there are that many number of actual wells drilled. It just means that the operator has the ability to submit that many APDs to that location. So well slots, again, not a formal term, sort of just our in-house term to talk about the number of wells approved on a pad. Of those 415 total well slots, 350 of those are new well slots. So basically in the OGDPs that were approved, 19 of those locations are new and 350 new wells are available to be permitted through the approval of a Form 2. So for the year to date, staff has approved 552 Form 2s or APDs. Those are individual well permits. And that includes wells that are associated with an OGDP and wells that are not associated with an OGDP. Recall that if a location is already built and has existing open well slots, an operator can still submit a Form 2 to get a new well approved onto an existing location. Next slide, please. So a couple of sort of what I thought were some interesting stats. Staff is currently reviewing 38 OGDPs. This includes forms or OGDPs that are in completeness review or in technical review. Of those, there are currently 72 Form 2As. Again, the Form 2A is the oil and gas location assessment. Crunching the numbers just from January through yesterday, the average length of time between passing completeness on an OGDP application and getting it to hearing is 103 days. So just over 3 months once an application passes completeness until it is heard by the commission. We also have 3 comprehensive area plans or CAPs under review. One of those will be heard today. The other 2 have passed completeness and are undergoing technical review with staff. Next slide, please. And then just I wanted to give a very quick update on the staffing situation. We do now have a full complement of staff in the oil and gas location assessment unit. Those are the folks that do all the surface permitting and are the primary drivers behind processing OGDP applications and Form 2As. We've got 1 supervisor, 1 senior OGLA specialist, 8 OGLA specialists. Previously we had 7. We've just created a new position, so we have 8 now, and 1 hearings liaison. That is a new position that was put into place as of April 1st of this year. In the permitting group, so that is the group that focuses primarily on the subsurface permitting and particularly the Form 2 well permits. There's 1 vacancy currently in the recruitment process. So we have 10 out of the full suite of 11 staff in the permitting group. I think that's the last slide for me now. And Angelica, yeah, this will be my next section in a little while. So thank you for that.
Thank you, Ms. Trask, for the update. And I think in discussions we've had, we want to try to have kind of quarterly updates so that we can, keep apprised of how things are going. Just quick question back on that well slot nomage. So do I get that right that like in some instances when there's an OGDP, it is on an existing location and there are wells that were already sort of approved there? So if you take the sum total of well opportunities, that would be the existing plus the new. Is that how I'm understanding well slot?
That is correct. We have a number of OGDPs that expanded existing locations. So just hypothetically, if there was an existing location with 5 producing wells and the operator wanted to expand that and put another 10 new wells, then the total well slots count would be 15. So 5 existing producing wells and 10 new wells.
Thank you. Thank you for that information. Are there questions? Commissioner McGowan?
Thank you. And I'm wondering if we have actual information about how many wells have been drilled this year, not just given permits for.
We can get that information. I'll have to seek some help from some of our amazing IT folks. We do get a Form 42 notice of spud for every well upon spud. So we can, I can work with our IT folks and have them run that query and pull those numbers for you.
Thanks, Sabrina. You could just add it to your, if this is going to be quarterly, the next presentation, that would be great, just to kind of see the landscape.
Perfect. I appreciate that timeline.
Thanks.
Other questions? All right, we will see you in a bit. Thank you very much for the update.
Thank you.
All right, next on our agenda and sort of last on our agenda is docket 2112-000237. This is a Kira-McGee oil and gas comprehensive area plan called the Bronco. And the order of play is going to be public comment, followed by Ms. Trask, followed by Jennifer Teeters with Weld County for a local government presentation, followed by a presentation from Kira-McGee in that order. So with that, we have public comment first. We had 2 public commenters sign up, I believe. Correct me if I'm wrong, Ms. Larson, but I believe we had Ms. Kate Merlin, as well as Dana Bovey, both signed up. So if we want to try to find those 2, then we will recognize them. Good morning. I'm not running a timer. We try to keep it within 3 minutes, but you're well aware of that. We look forward to hearing from you.
Thank you, commissioners. Good morning. I'm here to address the Bronco Cumulative Area Plan. The Bronco CAP Cumulative Impacts Analysis measures that the estimated impacts of 209 wells at 11 sites. Kira-McGee estimates that air emissions of greenhouse gases and criteria pollutants will peak in different years with 469 tons of NOx, over 500 tons of carbon monoxide, almost 100 tons of VOCs, 87 tons of methane, and 59,000, almost 60,000 tons of direct carbon dioxide emissions. Cumulatively to the project, more than 2,225 tons of NOx and more than 2,110 tons of VOCs will be emitted in the Denver Metro North Front Range ozone non-attainment area. For comparison, according to Regional Air Quality Council data, all the man-made NOx polluting our summer air on an average day amounts to 164 tons. So in 1 year, this project will emit 3 days worth of all the man-made NOx in the state, almost 1%. 1% does not sound like a lot, but this cap is only one of 3 under consideration, and this commission is considering dozens of OGDPs with even more hundreds of new wells. Oil and gas development already contributes 29% of all the NOx. It's the largest man-made source category. For VOCs, oil and gas development contributes 41% of all the man-made VOCs in the state, more than twice the next highest category, which is household products and paints at just 19%. EPA is finalizing our downgrade to severe ozone non-attainment. Our state desperately needs to reduce its emissions of NOx and VOCs. And just as Coloradans are being asked to stop driving their cars, this commission has to do its part to improving our summer air quality. Comparing the projected emissions from this project with projected emissions from the Crestone Box Elder cap, it becomes evident this commission lacks proper rules and procedures for evaluating cumulative impacts. So I want to keep this a little bit short, but if you look at the numbers of wells, the Box Elder cap has only 75% the number of wells. But it will emit at its peak only more than 84% of the peak emissions projected for Bronco, 52% of the peak projected emissions for carbon monoxide, twice as much VOCs, nearly twice as much methane, more than twice as much carbon dioxide. And then comparing HAP emissions, it will emit 175% of the benzene, but only 50% of the toluene, a third of the ethylbenzene, and 60% of hexane and xylenes. These numbers don't make much sense. And it shows the need for standardization in the measurements of cumulative impacts. Not only that, but the data being reported for cumulative impacts, they're not binding, they're informational for this commission. This commission is not going to reject a project on the basis that it has too much cumulative impacts. It never has. It's unlikely that it will. These operators just appear to be submitting very rosy projections because they're not going to be held to them. There's going to be no consequences for going over any of these projected emissions. Colorado is, I'll wrap it up. Colorado is choking on ozone. The entire planet is breaking record after record for heat. It's insanity to contemplate adding more wells, more VOCs, more NOx, more methane to this already suicidal situation. And that's not even including the downstream impacts of burning the fuels that are being extracted. We think that you should reevaluate cumulative impacts procedures, ask for more authoritative data, and we think that you should stop approving all of these wells.
Thank you for your comments. Are there any questions from commissioners? All right, seeing none, thank you very much for being with us this morning. Do we have Mr. Bovee?
Mr. Chair, I'm looking for Mr. Bove. I don't see him in the meeting. Mr. Bove, if you are in the meeting and could raise your hand, that will help us out. Not seeing anyone raise their hand, Mr. Chair.
Yeah, I'm looking too. I don't see him either. Why don't we move on to the next presentation and just keep an eye out to see if he joins us. All right, the next presentation on this docket is Ms. Trask again.
Thank you, Chair. I would like to actually take a moment. I think AG Davenport popped on. He might have some words that should be said before we.
Yeah, no, right. In pre-meeting discussions, we did discuss having AG Davenport give kind of a high-level summary of our CAP rule, since this is the first time we've used it. So AG Davenport, you're recognized.
Thank you, Chair, and thank you, Ms. Trask, for that. Commissioners, I have been asked to give you what I think is going to be a very high-level review of the CAP rule, Rule 314. The way I've thought about it is just to give you my summary of what a CAP is and what it isn't. And so I'm going to start with what I think is the most helpful thing, and that is what a CAP is not. A CAP is not a permit. It is not an OGDP. It is not approval that allows an operator to construct any surface facilities or drill any wells. If you approve today's CAP or any CAP, the operator still must obtain an oil and gas development plan, drilling and spacing unit, Form 2A and Form 2. So that is what a CAP is not. It is not approval of a permit. It does not allow any person to go out and start constructing a surface location or drilling a well. What a CAP is a landscape level plan for how an operator intends to develop oil and gas for specific subsurface formations in a large geographic area. And it is, as the name indicates, a plan. An approved cap can convey a series of 5 rights to an operator. An operator does not have to request that the commission grant all of those rights. And in this case, the applicant is actually not requesting the commission grant the 5th right, referred to in the rules, preliminary siting approval. Those 5 rights that can be conveyed if the commission approves the plan are, first, the exclusive right to develop the formations applied for. So that's just the subsurface that the operator intends, the formations the operator intends to produce oil and gas from. And that is the exclusive right to develop those pursuant to the commission's authority. It doesn't convey any actual mineral interest to the operator, it didn't previously had. What the commission is conveying is that it will not approve anyone else's applications for OGDPs within those cap lands. That there's a limited time period for which the cap applies, and that is the second quote unquote right. The default time period stated in the rule is 6 years for which the cap is applicable, and the other rights granted apply then for 6 years after the commission grants the cap application. The third is, if the commission approves the cap, the operator is not required to submit a Form 2B cumulative impacts analysis as part of future OGDPs in the cap lands. So the commission conducts overarching cumulative impacts analysis for the cap, and the rule does provide, if the cap is approved, the operator need not submit that additional or other cumulative impact analysis on an OGDP by OGDP basis. Finally, in this application is the 4th right, which is an expedited review of OGDPs pursuant to Rule 306D. Rule 306D provides that in normal OGDP circumstances, the director must issue a recommendation within 120 days of completeness. In this case, upon approval of a cap, that time period is reduced to 90 days. The final right conveyed, which is not at issue here today, is what's called preliminary siting approval. And in effect, if requested by the applicant and the commission approves the cap, that allows the operator to forego the alternative location analysis if required when it submits an OGDP. But again, none of these rights are actually approval of a permit to conduct surface facilities or a permit to drill. Mr. Chair, that concludes my remarks. Of course, I'm happy to answer any questions.
Thank you, AG Davenport. Does any commissioner have questions? Well done. There are no questions. All right, Ms. Trask, I believe you're up next.
Thank you, Chair. If we could get the slides started up again. Wonderful, thank you. Commissioners, I have just a brief presentation to describe staff's review of the Kerr-McGee Bronco cap application for your consideration today. Next slide, please. So I've got sort of a series of 3 slides and then a series of 3 slides. I'll first go over our review process and then sort of the general timeline of what the application process looks like in general, both in general and specifically for this cap application. And then I'll get into some of a little more detail about what staff looks for during this review. So staff received Kerr-McGee's application for the Bronco cap via our e-filing system on December 13th of 2021. I just want to remind that since this is a cap application, the application materials are entirely submitted as a hearing application and exhibits into the e-filing system. There are no Form 2As, 2Bs, or 2Cs associated with a CAP application. And as AAG Davenport mentioned, this CAP application is not seeking preliminary siting approval. They do discuss potentially 11 oil and gas locations, but those are conceptual locations only and are definitely subject to change. Should this CAP be approved, there will be an opportunity for those locations to change or be fine-tuned through the future OGDP process. So once the application was received, we undertook our completeness review of the application. So there's two primary components or staff groups who do this completeness review. Our permitting team reviews the application for compliance with the 500 series. The 500 series, I'm sure you know well, is the hearing application or the hearing general requirements. The permitting group also reviews the general mineral development, so sort of looking at the subsurface requirements. Again, there are no specific wells associated with this. It's just a general overview of the mineral ownership. And then for the surface review, our oil and gas location assessment or OGLA team reviews the application for compliance with Rule 314. That's the Rule 314 is the CAP rule in our rules. This application passed completeness on April 21st of this year. Next slide, please. Upon passing completeness, that opened the public comment period and the consultation period. We did receive approximately 114 public comments. Those comments were received through our largely through our public comment portal. We did review every one of those public comments and address them in the director's recommendation. We also undertook consultations as required with Colorado Parks and Wildlife, with CDPHE, with Weld County, who is the only local government associated with this CAP area, and the BLM. Those consultations were also summarized in the director's recommendation. Simultaneously with the public comment period and the consultation period, the OGLA staff commenced their technical review, and I'll get into the details, some of the details in that momentarily. Staff did publish the director's recommendation on July 22nd of this year. Next slide, please. The CAP application was scheduled for hearing today. I think that's why we're all here. And then sort of looking forward in the process or in the timeline, if this CAP is approved, there will be a whole additional subset of tasks that will be that will happen basically. So if this CAP is approved, the applicant will have an opportunity to submit their OGDPs. I don't know if that will be one OGDP per location or a series of, OGDPs with multiple locations. That's entirely up to the applicant. Those OGDPs will basically proceed similarly to a regular OGDP process. So it'll have the Form 2A. The Form 2As will have alternative location analysis attachments as applicable. They will have the BMPs. They will have the plans to include the cumulative impacts plans. They will have all the necessary and required attachments. There will be a public comment period open for each OGDP application, and there will be consultations as required by rule as well. As AAG Davenport mentioned, these OGDPs will undergo expedited review per Rule 306D. That means that once those OGDPs pass completeness, staff will undertake to get those to hearing within 90 days. Those OGDP applications will go to hearing, so the commission will have an opportunity to make specific decisions on those exact proposed locations. So if you should approve this CAP today, just keep in mind you are not locking in these locations. Those locations will be effectively locked in and approved at the OGDP level at the commission hearing. Next slide, please. So I want to just talk a little bit about what staff looks for in the technical review of a CAP application. As AG Davenport mentioned, a CAP application it's not a permit. It does not grant any permission to conduct operations either on the surface or in the subsurface. It's really a conceptual plan or a preliminary plan. It's meant to describe the operator's intent to develop minerals over a long period of time, in this case, 6 years per the expiration, or rather 6 years prior to expiration, through a thoughtful, integrated plan. One of the, I think the finer points of this is that it allows, the CAP allows for fine tuning the details at the OGDP level over time. So this is really meant to provide a mechanism for an applicant to do an overall landscape level plan. This will effectively eliminate a patchwork approach. In years past, there have been cases where the commission, under multiple prior rules, where the commission would approve a location and then approve a location across the street from it, and then approve another location a quarter mile away from those, and then approve another location across the street from that location. And so you end up with situations where there are multiple locations within very close proximity to one another. The CAP avoids that type of patchwork approach and really gives operators and the commission an opportunity to do a well-thought, well-constructed plan over a large landscape area. So some of the items that we dig into in these CAP applications include infrastructure, consolidation of equipment, consolidation of locations, and certainly timing of operations. Next slide, please. Cumulative impacts are evaluated for the whole project, the entire CAP development area, rather than individual locations as they are in an OGDP application. So Rule 314 has a lengthy list of required information that the applicant should provide or must provide as part of their CAP application. The requirements in Rule 314 are similar to those requirements that are on the Form 2B in content. So there's air emissions, there's public health, public welfare, soil, water resources, wildlife resources. I'm sure I'm missing a few. At the CAP level, this cumulative impact data is admittedly, it's less granular than on the Form 2B, but it's more comprehensive in that it connects the dots between the locations. So instead of looking at one specific location as is done through an OGDP and the Form 2B, it's looking at the whole area and looking at the cumulative impacts throughout that area, not just at this spot, at this spot, at this spot, and at this spot. The CAP cumulative impacts will be included in our CIDR, which is the Cumulative Impact Data Evaluation Repository, and will be included in staff's Cumulative Impacts Annual Report. Next slide, please. BMPs are another hot topic for OGLAs during the technical review of a CAP application. We approach BMPs as sort of an indication of the operator's general intent. Since a CAP application does not grant permission to actually go out into the field and start putting in BMPs, they're a little bit more vague as part of the CAP application. Those BMPs will be fine-tuned at the OGDP level. So what we're looking for in a CAP application is for the applicant to focus on large-scale framework, BMPs related to large-scale frameworks such as pipelines. Again, having the BMPs, the specific, site-specific and very well-crafted BMPs going on the OGDP applications and on the Form 2As at a later date gives us a little more flexibility and gives the applicant more flexibility to really fine-tune those BMPs for the individual sites rather than just doing a blanket BMP in the CAP that might not actually apply once the given location or proposed location is identified. So having BMPs primarily focus on the OGDPs and the Form 2As is important because there could be improved technologies that come about in the future. And so if we assess a cap level BMP today, there might be a better BMP 3 years from now, that we would want to see that operator implement at that location. There also could be changes to the surrounding area that might require revised BMPs or additional BMPs. So again, having the flexibility to really fine tune those BMPs at the OGDP level is important. It's also important to note that BMPs, again, since a cap does not grant permission to go and do groundwork, there's not really a good way that staff can enforce BMPs at the cap level. So having those really fine-tuned BMPs at the OGDP level and on the Form 2As is significantly easier for field staff to go out in the field, observe the operations, and determine whether or not those BMPs were in place and successful. I think that is my last slide. Yes, thank you. I'm happy to take any questions, commissioners.
Thank you, Ms. Trask. I've got two quick questions, kind of follow up to some of the slide deck. You indicated that the cumulative impact information will make its way into CIDR. My understanding is that generally that information makes its way into CIDR via the 2B. And then if this were approved that doesn't do 2Bs, can you provide some additional perspective on how we might ensure that that is happening? And you may not have the answer yet, but if you're working on it, that's fine too. I just wanted to frame that question.
Yes, thank you for the question. That is definitely a good question to ask, and I appreciate it. We don't actually have a mechanism right now. You are correct in that the mechanism that gets cumulative impacts data into CIDR is through the Form 2B. We are working with our wonderful and amazing IT staff to find a sort of a workaround before the end of this year. So before we are working on that annual report. We have definitely flagged it for staff. We've got a couple of ideas. I'm not sure I want to daylight those ideas right now because I don't know which route we're going to go, but we will definitely get that information into CIDR. I don't know what it will look like because the Form 2B and the Rule 314 cumulative impacts data are not totally apples to apples. They're close. They're sort of, apples, I guess, to oranges or apples to pears maybe. And so we'll have to do a little bit of creative thought to come up with the best mechanism to get that into the CIDR database, but we are working on that.
And following up to that, the apples to pears or, cherries to plums or whatever you want to call it, the data you mentioned in your testimony is less granular, but more comprehensive because it connects the dots for the whole area. This commission created this rule. This is the first use of this rule. Sometimes when we're using rules, we find intended consequences and unintended consequences. As a manager in this area, are you finding that the data is, if it's not quite the same, if it's cherries to plums, is it good enough in order to advance our cumulative impact goals? Does that question make sense?
Yes, it does. And thank you for that question. I do think it is good enough. I will caveat that by saying on a personal and selfish level, I wouldn't mind a little bit of rule cleanup to sort of bring them a little bit more in alignment. But I do think that they are close enough, and I'll describe why. The Form 2B, so at the OGDP level, that requires emissions estimates for the first year of production. So it gives you a 1-year glimpse of emissions. The CAP gives you we'll just use the word 30, a long term over the life of the operations, a 30-year glimpse of emissions. So you've got a 1-year data set and you've got a 30-year data set. Those initially don't seem to match, but the Form 2B also requires the applicant provide the number of months of total production. And so we could theoretically take the 1 year of production data, multiply that by the, do the math with the number of months and come up with a sum total emissions estimate over the life of the project. That would effectively match, or rather equate to, the sum total as provided in a CAP application. So they're not apples to apples at face value, but we do have the resources and the ability to sort of convert the Form 2B data into something that is much more equivalent to the data required in a CAP application.
Okay. And again, I appreciate the thought that you have there on sort of rule cleanup. I think as with all of the rules, we just need to, use them, see if they're accomplishing the goals. During mission change, we developed the CAP to create some incentives because we felt like there were some positives to this landscape level planning. We may need to reevaluate that, but I appreciate you've got your thumb on that and that you're thinking about that as well. My last question has to do with something different. I've always had concerns when we, or when any regulatory entity provides lengthy vested rights for operations. When I was a local government lawyer, that was always at the forefront when I was developing operator agreements that had lengthy vested rights. And the concern I always brought to the client, the concern I bring to the table today with my commissioner hat on, is the concern of, and it was speaking to the BMPs and the fact that, you and your staff have decided that it's more appropriate, look at sort of the big picture BMPs, pipelines, et cetera, great. But for the more granular BMPs, you want to focus those on the 2A and the OGDPs. And I appreciate that because that's closer in time to actual drilling. And we don't lose the improvement in technology that happens yearly with this, with this industry. Do you feel comfortable that the approach that we've got here, where we're potentially doing CAP today, and then we do BMPs and OGDPs, one at a time, that is preferable in terms of ensuring the best BMPs or the most improved BMPs closer in time to drilling? And my second part of that question is, I still have a concern because they could come in and ask for an OGDP next week and then not drill it until 2028, right? And how do we address that? And I guess I'm also looking at the applicant's attorneys you need to address that to my satisfaction, because that's something that is a concern. It's part and parcel of a CAP. At the end of the day, we may get the appropriate balance of positives for this, but it is a concern. So I don't know if that's a question or if that's throw you out an opportunity to comment, et cetera.
I might just try to sort of respond to some of that. I might have got a little lost in the middle somewhere. I do think that this is a good approach, having sort of large scale or umbrella oversight BMPs as part of the CAP application. So when we're looking at things like oil and gas takeaway, those types of BMPs, that infrastructure that will cover, a significant portion of the CAP lands, throughout the CAP lands, or access roads, once the access road kind of leaves the pad, where does it go? What does it connect to? What are the haul routes? And so kind of looking at some of these larger scale, basically non-location BMPs at the CAP level, I think is appropriate. And I do think that focusing the bulk of the location specific and site specific BMPs at the OGDP level is the right place for it. As you mentioned, as I mentioned, this industry is really innovative. There's always new things being developed, new BMPs being designed, new equipment being utilized. And so I do think it's important to have the flexibility that those specific BMPs to address potential impacts at at a known and given location is best served at the OGDP level rather than at the cap level.
Okay, thank you. Thank you for that. Thank you for this supplemental director's report, or whatever we want to call it. I think it's really helpful to commission. I applaud you and staff for all the great technical analysis that has been done on this cap. And now I'm throwing you to the rest of the wolves. Does any other commissioner have questions for Ms. Trask? Commissioner Bessner?
Thank you, Mr. Chair, and thank you, Ms. Trask. Always helpful to hear from you, and thank you for all the work that you and your staff have done on this application. I wanted to follow up a little more on the BMPs and intent of BMPs for caps versus intent of BMPs at the OGDP level. And I guess I'm making some assumptions that as we look at landscape level, I mean, the cap is a landscape level, preliminary plan, but in order to address some landscape level issues associated with, the cap, there has to be some landscape level BMPs that would carry then on to each OGDP that's associated with this particular cap. And I think I'm hearing you say that, whether that's, oil and gas takeaway infrastructure, or potentially electrification or non-electrification, or other big picture stuff. And so is it your belief that in a cap, if there are certain big picture BMPs that are being proposed, that they need to be proposed in a way that's clear that the operator, does intend to commit to these, and that they would then carry on to any and incorporated in any OGDP BMPs further on down the road?
Thank you for the question. That is a good question, and that's a question that my staff and I have talked quite a bit about internally. I'm going to punt a little bit and say that I think that's a question for the applicant. Since this is the first cap application that we've heard, there's a little bit of uncertainty about what BMPs on caps truly represents. And so I would posit that it is up to the applicant to make a statement either confirming a commitment or confirming this is not a commitment, it is merely an intent or a plan. I think that having the applicant make that sort of clear statement is what you might want to be asking for. Staff doesn't really have a strong opinion, because we can't tell the applicant, you will commit to these BMPs. It's really on the applicant to make that determination and then make that intent or commitment very clear to the commission.
Okay. Thanks for that. The other question I have is around, similar to Chairman Robbins, and the cumulative impacts and how these things tie together to create accurate information for our cumulative impacts reports, and understanding that some of the granular BMPs could be proposed at the OGDP level, and to your point, probably should be at the OGDP level. At the same time, some of these BMPs, both at the landscape level and the OGDP level, do have impacts to the qualitative or quantitative data that's provided in a cumulative impacts report. And how in your mind do we work, how do those things work together in order to get accurate information at the ultimately the 2B style level, so that when we do the CIDR database, it's accurate information that we're providing? Yeah,
another good question. We're not entirely sure, and again, I'm working with our IT group. We're not entirely sure. So the data fields on the Form 2B would effectively be different than if there was a cap 2B. The data fields don't, they're close, but they're not the same. They don't match. And so one of the things that we're discussing is having sort of a cap subset in CIDR, where the cap data required by Rule 314 comes into sort of a separate a separate, box in CIDR. I'm not sure that that's the right answer. I'm not really sure how to answer your question. We're trying to, it's a newly discovered dilemma as we've been working through this CAP application. We've only realized that this is really a potential conundrum in the last couple of months. So I apologize. I don't really know how to answer your question.
And that's fair. I'm not trying to put you on the spot either. These are just questions that are in my mind, right? And so, the other question along those lines, I mean, it appears like it would be super helpful that once we did get down to the OGDP level, that a 2B did get submitted that clearly indicated this is the BMPs that we have decided to do on site, and therefore we can update that information that we provided at the CAP level at the OGDP level in order to be able to provide accurate information. I mean, that would be super helpful, wouldn't it?
It would be. And if the applicant volunteers to provide the Form 2Bs with their OGDP applications, that would make my life wonderful. But they're not required to per Rule 314.
And I understand that. That does, without it being required in Rule 314 though, and should they not be willing to do it at the OGDP level, which I understand, I think that becomes even more important, that there's more granular information at the CAP level review in that cumulative impacts report. But that's not a question, that's a statement. The other question that I have is, and again, understanding that Rule 314 doesn't contemplate landscape level views to avoid, minimize, mitigate potential impacts to all the different receptors, one of them being wildlife. And the CAP really is an opportunity for wildlife to be addressed at the landscape level, which is great because that doesn't often happen in land use change reviews or oil and gas permitting, because we're looking at it at a more granular level. Also understanding that the CAP submittal requirements only require a quantitative analysis of potential impacts to wildlife habitat. What kind of tools or what discussions occurred during that consultation with CPW? Because there wasn't a lot of detail in the application as far as that conversation that would be helpful in analyzing potential impacts to wildlife at a landscape level rather than waiting until the OGDP level to look at that, which I think is one of the huge advantages of the CAP.
So I'd have to refer back to my notes, the CPW consultation we had with Brandon Moret, and I think Brandon is available today to answer specific questions that you might have. My recollection of the CPW consultation was that it was a very robust discussion and that CPW asked some very specific questions of the applicant that the applicant had to sort of stop and think about a little bit. And so I felt that Mr. Moret's questions gave some really important prompts that the applicant was able to take back and sort of provide some additional thought. And I think the result of that will be seen in the OGDPs as part of the wildlife mitigation plan. It is likely that there will be either direct or indirect mitigation fees, but those again will be assessed at the OGDP level. I kind of want to defer to CPW staff in answering that because I only have my impression of what the consultation was, but I did come away from that consultation thinking that some very important questions were asked of the applicant, sort of prompting them to give a little more thought to the landscape level planning for wildlife protection.
Great. Thank you very much, Ms. Trask. That was super helpful.
You're welcome.
Great. And I took a look and Mr. Moret is indeed with us, so we'll be able to ping him with questions at the appropriate time. Other questions from commissioners? Commissioner Cross, then Commissioner Ackerman.
And I'll admit, this is probably less of a question and more of a statement, kind of building off some of the prior discussion we just had. And I'll be honest, I think part of the way that I interpreted our rules and regulations would be that the BMPs at the cap level would be binding throughout the process. And so I appreciate your input that there seems to be a little bit of uncertainty on the staff's behalf that may not be the case. And to the extent that that's not the case, I too think it would be important, and this is, I think, where my comment comes in, for the operators to talk about that aspect, because to a certain extent, I sort of view this as the foundational basis of future development, should future development be approved. And to the extent that that is a foundational basis, I think it almost makes any BMPs agreed to at this point in time somewhat meaningless if it's not going to apply throughout. And I think if our goal is efficiency, both in the review process, efficiency in consolidating equipment and everything else, that I think it's important that we don't obfuscate that process, and that we do make sure that we are on the same board that any BMPs agreed to at this point in time would be binding throughout. But I also want to reiterate the appreciation for your comments, because I do think that's very helpful.
I see that AAG Davenport's popped up, so I'm going to defer to him, but I did want to just say that staff feels that BMPs included in the CAP application are binding. The issue is that they're not necessarily easily enforceable by staff. If the BMP is to use an electric rig, and the OGDP doesn't get approved, there's nothing to enforce. There's, nothing happens. And so there's the nuance, I think, is not so much that it's not binding. I think the nuance is how can staff enforce it if it's not followed? And I should probably stop talking and let AAG Davenport speak.
Can you follow up AAG Davenport?
Yeah, at the pleasure of the commission, I wanted to, and I agree with everything that Ms. Trask just said. I want to, maybe it's helpful to clarify that what the commission is obviously reviewing and approving today is the CAP, the comprehensive area plan. And if the commission approves the CAP, then that's what you're approving. You're approving the operator's plan for future development. And the operator should comply with that plan that you approved going forward. Or in my view, certainly risk OGDPs being denied, but also risk the commission at some point in the future saying, hey, why should we continue to allow you to operate under this CAP when you're not complying with it? What that means potentially to me is, and recognizing this is a new process, that operators should submit OGDPs consistent with the CAPs. Ultimately, if, recognizing this is a 6-year time window, and 4 years from now, if something changes to the extent that there's a better BMP out there or different equipment, that doesn't mean that staff has to approve the exact BMP set forth in the CAP if there is a more protective one out there or a one that better fits. But operators at minimum should submit OGDPs that are as protective or consistent with the CAP and the BMPs in the CAP. And that includes, at least in my view, if there are things that don't normally go into an OGDP, for example, infrastructure like roads or pipelines that you wouldn't necessarily put, miles and miles of pipeline maybe into an OGDP, but they're approved in a CAP. The operator should construct those things consistent with the CAP as well, or come back to the commission and request a modification to the CAP. So I hope that clarifies things a little bit as to what approval of the CAP means today. And you're granting the rights that I discussed earlier. You are also, if you approve it, approving the plan the operator submitted, and the operator should conduct themselves consistent with that plan.
Thank you, AAG Davenport. Helpful. Commissioner Ackerman, I believe you had a question. or two.
Thank you, Mr. Chair. I appreciate that. And thank you, Ms. Trask, for your presentation. Very helpful. I think Councillor Davenport partially answered this question for me, but really thinking along the same lines as the two commissioners who commented before me, and really the inverse question of Commissioner Messner's is what I have, which is if there are a series of BMPs included in the CAP, I just wanted to affirm that later on in the OGDPs, if there's a BMP that becomes apparent that would be helpful in the approval of an OGDP, but it or its umbrella is not mentioned in the CAP, do we still have the ability to include that BMP at an OGDP level? So that's my first question.
I think the short answer is yes. The OGDPs, staff would expect that OGDPs have additional BMPs that are not included in the CAP.
Thank you, I appreciate that. And my second question is something I've been pondering as I've been perusing the materials, and that is that the intent of a CAP is to, as you've pointed out, cumulatively assess and address to the extent possible the impacts of any particular series of projects. One of the things that is interesting with this one is that preliminary siting is not being requested. And so all of the information that ultimately will be developed, isn't available at this point. By design, it's not available at this point. The presumption is that the reason that OGDPs are not then required to provide separate cumulative analyses is because that cumulative analysis would have been done at the CAP level, ergo they're exempt from having to do it a second time on a site-by-site basis. But can you talk a little bit about when we don't have all the information, for example, specific siting of facilities helps us understand the impact on wildlife over time. When we don't have that information at this level, and if they're exempted from analyzing those cumulative impacts at the OGDP level, where does that come into play? How do we analyze how the siting impacts wildlife and other aspects?
Thank you for that question, Commissioner. It's another good one. You guys are grilling me pretty hard today. I want to say that with regards to wildlife in particular, we're a little bit lucky in this first initial CAP application. There's one high priority habitat. I believe it's pronghorn. It's a large area of high priority habitat, and the bulk of the planned or conceptual locations are within that habitat. And so our consultation and our work with CPW staff has been really, really helpful for our staff to understand the potential impacts over that large scale area. The fact that these locations at this point or that this CAP is not requesting preliminary siting approval, we're a little bit lucky in that we have received indications from the applicant sort of outside of the CAP itself, just sort of in our conversations with the applicant and with Weld County, that these locations are fairly certain. Although there is room for revision of these locations at the OGDP level, staff feels fairly confident that the locations as sort of preliminarily planned in the CAP are very likely very close to the locations that will be provided to us at the OGDP level. And so with that sort of maybe internal knowledge, we feel pretty comfortable that through the discussions with CPW that the impacts to pronghorn will be successfully addressed at the OGDP level. How this would happen under different circumstances if there were, proposed or planned locations that were very vague and very up in the air. I'm going to sort of cheat a little bit and say we'll figure that out if and when we have to. That's not a great answer, but I do feel fairly comfortable with these planned or conceptual locations that have been provided to us as part of this CAP application.
Thank you so much, Ms. Trask. And honestly, figuring it out when we've revised the regulations is part of the process. And so thank you for the efforts to do so.
Thank you.
Mr. Chair, is it all right if I chime in for one moment? Thank you. Commissioner Ackerman, commissioners, I wanted to note one other thing. Rule 314H, which is the last part of the Rule 314 and the last part of the 300 series as well, does provide for the options essentially in regard to commission consideration of a cap. And the very last provision of 314H briefly discusses changes to an approved cap and the process by which that would occur, which must include commission review. While I think everyone recognizes that the proposed locations in today's cap that you're considering are conceptual and not set in stone, this would be the process, changes to the approved cap, bringing it back to the commission. Should there be, certainly should there be significant changes to the proposed locations. In my view, and recognizing this is a new process, should an applicant receive an approved cap that has, even if it doesn't have preliminary siting approval, consideration is based on somewhat specific locations, and at some point in the future, hypothetically, all of those or some of those changes, those locations change significantly, that I think this would be the appropriate process to address that and figure it out. They should come back before the commission, or staff should raise it with the commission, or somehow it should come back to the commission that there's been significant changes to the approved cap that need to be reviewed.
Thank you, Counselor. That's helpful.
Thank you, AG Davenport. Are there further questions? All right, seeing no further questions, Ms. Trask, we do really appreciate you fielding questions. I think Commissioner Ackerman got it right, that as we move through a new rule for the first time, there will probably be more questions than not. And you and your staff are doing a phenomenal job of addressing the technical aspects of this new rule. And so we really appreciate it. So we'll let you go, but don't go too far because we may have further questions later on as we contemplate this docket.
Understood. Thank you for the opportunity to speak today.
All right, commissioners, I'm going to suggest we hear from Weld County. Jennifer Teeter, I believe, is going to present. And then after that, I'm going to suggest we take a morning break because then we'll hear from the applicant and they've got quite a bit of time set aside for that presentation. Ms. Teeters, see your hearing before us. Hey there.
Good morning, commissioners. My name is Jennifer Teeters with Weld County Oil and Gas Department. This is my first time presenting on Zoom, so can I just confirm that you can hear and see me okay?
We can hear and see you just fine. It's great to have you with us.
Awesome, thank you. So I'm here today just to make some brief comments on behalf of Weld County in regards to the docket item before you, which is the Kerr-McGee Bronco cap. Jason Maxey is unable to attend, so I am filling in for him. On June 9th, the COGCC held consultation with KMG and Weld County pursuant to Rule 314F4AI. There were multiple items discussed at this meeting to inform the COGCC and Weld about the proposed cap. The items are specifically called out in COGCC rules, current land use and all future planned uses of all areas within the cap, and cumulative traffic impacts, which is Rule 314F4A, II, AA, and BB. For the commissioner's benefit, the current land use is rangeland, which is zoned ag. Weld has no knowledge of this type of use changing in the future, as the current use has been in practice for many years. The proposed access to the cap does not utilize any county roads. It accesses directly onto a state highway, which is Highway 34. Therefore, we do not believe there should be any concerns with traffic. It is our understanding that KMG is not seeking preliminary siting approval. Therefore, we had no discussion relating to Rule 314F4A, II. On July 6th, Weld County received a pre-application meeting request for the Bronco CDP per Weld County Code, Section 215315A. It is important to note that the boundary or development area for the COGCC CAP submittal matches the boundary for the Weld County CDP submittal. On July 20th, Weld County hosted the pre-application meeting. In attendance were multiple representatives from Weld County, Kerr-McGee, and the COGCC. The CPW had one representative attend the meeting. A representative from CDOT was invited, however, they did not attend the meeting. Meeting notes were sent to all invitees and attendees on August 2nd. CAPs and CDPs are good planning tools. From the county's perspective, we're able to gain further insight into future development plans compared to what we see with individual permit submittals. We are able to consider the full development area when looking at cumulative impacts or infrastructure items. And they also create a public record of full phase development, which helps to prevent future land use conflicts. Thank you for your time, commissioners. And to be able to make these comments this morning. Weld County is supportive of the KMG Bronco CAP and looks forward to working with KMG and the COGCC at this plan.
Thank you, Ms. Peters, for the appearing before us and for the comments. I do appreciate it. We believe that the relevant local government input is an important component to our consideration. And so we thank you and Mr. Maxey and your team for that input into this proposed Bronco CAP. Are there questions? Commissioner Messner?
Thank you, Mr. Chair. Thanks, Ms. Peters, for your presentation. I might have missed it, but the review, the Weld County review of your CDP is at what stage of review?
Sure. Yeah, we hosted the pre-application meeting. At this point, the applicant is allowed to submit the notice. We, after the notice is received, we have a 30-day holding period and the application. So at this point, we have not received the application.
Okay, so this is one of those scenarios where there's potentially a COGCC decision prior to the local government decision on this type of application.
I believe so. And from my understanding, a very similar process to what the COGCC has is that the CDP goes in front of hearing for the development area. And then the applicant is to submit individual applications for those individual well pads. Those do not go to hearing. They still get noticed and such, but you are correct. This is before the COGCC and we do just have a similar process, I would say.
Okay. And so, and that just because I'm curious, the CDP process within Weld County, does that have a preliminary siting associated with it? I mean, I know you said that they have to get the final permits, site-specific permits, but is there like ALAs or preliminary siting associated with the CDP process, or is that all done at the individual permit level?
There is, we do look at kind of their locations, again, the infrastructure that's in the area such as pipelines, and see where their planned locations are and seeing if there are any other alternatives that might push them out of high priority habitat. That's all takes place at the pre-app meeting. It is very high level. Again, when we get the application in, that is part of our required information for the applicant to show on the development area map, the alternatives that they've selected, the pros and cons, and why their proposed location is the best in their opinion. And then, so we still have the opportunity not only to, so we discuss it in the pre-application, we discuss it in the CDP hearing a little bit. And then when the application comes into our department, we review it in the application and have the ability to kind of have either pushback or dialogue about those alternatives. So there's, I would say, 3 opportunities for Weld County to interact with the applicant with those alternatives for a CDP location.
Okay, and just last question to make sure that my notes are correct, but preliminary application happened for the Weld County CDP, or preliminary meeting has occurred, consultation. There's notice that has gone out, and you're in a 30-day waiting period prior to the required submittal of the application. Is that kind of right?
I am going to ask the gal who is handling this CDP. I'm not sure if the notice has been received yet by Weld County. We just hosted the meeting and the meeting minutes went out yesterday. So as soon as the meeting concludes, they are able to submit the notice. I'm not sure if we have received that, so I can confirm, but at this point, we've only had the meeting and there's at least, if the notice was received, there's at least 3 weeks before we're able to receive an application from them.
Okay. Thank you very much for answering my questions.
Other commissioners with questions for Weld County and Ms. Teeters? All right, I'm not seeing further questions. Commissioners, our agenda is a little bit different today. It didn't have a morning break and then I had an early lunch break at 11:15. I don't know if that was on purpose. I would rather take a 10-minute break now, give the applicant a chance to get ready and then hear from the applicant. And then perhaps after that, we could take a lunch break. Is everybody okay with that? All right, I'm seeing nodding of heads in up and down fashion. So let's return at 10:30, a little bit more than 10 minutes, and we will then hear from the applicant. The applicant's attorneys obviously have listened to all the questions, and so we would instruct them to be prepared to kind of add on to answers in these areas of inquiry from commissioners. So with that, we'll return at 10:30. We will get started again. If we could stop sharing the screen from our hearings manager, and then we will recognize the applicant and the applicant's attorney. Good morning, Ms. Jost.
Good morning.
I believe that you guys are ready to go. Do you want to make sure that you've got everybody in the panel that you need at this time?
Yes, that would be great, Chair. Thank you. I'm just looking. It looks like, and there was a lot of people to add, so Mimi, thank you. I think the only person we are missing is Andy Lytle.
All right, let's get Mr. Lytle to the panel.
And I see him. So I believe we are now ready to present.
Very good. Well, the floor is yours.
Great, thank you. Well, good morning, commissioners, staff, council, and members of the public. My name is Jamie Jost from Jost Energy Law, and I, along with my partner, Kelsey Wesselinki, represent Kerr-McGee Oil and Gas Onshore LP in this uncontested Rule 314 Bronco Comprehensive Area Plan application. Kerr-McGee is very excited to present the first full Rule 314 CAP application to come in front of this commission as a result of the 2021 mission change rules, and we look forward to the discussion today. AAG Davenport and Sabrina Trask did a wonderful job explaining Rule 314, the purpose of the rule, and the process and procedures that the director and staff undertake when reviewing an application for a comprehensive area plan. As an expansion of their presentations, I would like to take a few minutes and review Rule 314 from an operator's point of view and talk to you a bit about Kerr-McGee's Bronco CAP. Kerr-McGee was highly involved in the mission change rulemaking and the evolution of Rule 314 as the rulemaking proceedings progressed up to their adoption on January 15th, 2021. In reviewing the adopted Rule 314 and applying it to Kerr-McGee's assets on the Survey Ranch, it soon became clear that a CAP was the route to take for purposes of comprehensive development of this singular landowner's property. Kerr-McGee has fully adopted the Commission's intent to encourage operators to submit CAPs because of the significant benefits that landscape level planning provides for consolidating infrastructure and minimizing cumulative impacts, and it continues to progress the benefits of the CAP as it develops the underlying minerals within the CAP boundary by applying significant protections to the surface and the surrounding communities. The Bronco CAP application and the lands and minerals ultimately governed by an approval of the Bronco CAP illustrates the usefulness of the CAP as one of the Commission's tools when evaluating the cumulative impacts of oil and gas development over a broad geographic area. and to address those cumulative impacts by developing infrastructure and other planning allowances in a way that minimizes surface disturbance and other adverse impacts. Without stealing the upcoming presenter's thunder, the Bronco cap will only have 11 oil and gas locations for the development of up to 209 horizontal wells. It will result in an estimated surface disturbance of one singular surface owner's property to approximately 76 acres after interim reclamation. It has 0 residential building units within 2,000 feet of any of the potential locations. It has 0 high occupancy building units, 0 schools, 0 daycares, 0 public water systems, and 0 disproportionately impacted communities within its boundaries. And although high priority habitat does exist, Kerr-McGee has already consulted with CPW on the cumulative impacts to such habitat and the continual discussions and evaluations that will occur as the individual OGDP process is initiated for the development of an approved cap. So although Kerr-McGee is not requesting the voluntary preliminary siting approval under Rule 314 for this cap application, it has worked extensively with the singular surface owner over many years to reach an agreement to site 11 oil and gas locations on an existing utility and road corridor, to consolidate 19 potential locations to 11 locations, and to ensure that significant best management practices are employed on each oil and gas location utilized to develop the 24,300 acre cap. Specifically, Kerr-McGee has already committed to apply almost 50 best management practices and mitigation measures to each oil and gas location within the cap boundary, with over 35 more BMPs to be considered and analyzed as each oil and gas location makes its way through the site-specific OGDP process with the county and the state. Many of the confirmed BMPs were adopted through the formal consultation process with CPW, CDPHE, and Well County, and this serves to illustrate the beneficial nature of the CAP stakeholder process. Chair Robbins, to address your question to Sabrina as well as Kerr-McGee's counsel, the beauty of the CAP process is that it's not the final decision on oil and gas locations like you would have in a typical OGDP application hearing. There are numerous additional opportunities for this commission to request new BMPs or COAs or for the CAP development, as well as commitments to those BMPs at the next stage in the process, the OGDP and Form 2A application stage. This commission contemplated placing future BMPs, COAs, and potential commitments on operators at the OGDP stage in the development of the CAP by incorporating this statement into the statement of basis and purpose. The commission and director will review those future Form 2As on a case-by-case basis, taking into account potential changes in land use between the date the CAP was approved and the date the Form 2A was approved, as well as best management practices and conditions of approval that may be necessary and reasonable to protect public health, safety, welfare, the environment, and wildlife resources. This continual future development of BMPs and COAs is really important to Kerr-McGee because not only does it allow for continual discussions with the state, the commission, and stakeholders about the development of the CAP during the OGDP stage, but it also allows for the evolution of technology to be implemented in a future OGDP review. It allows for further commitments to be made by the operator at the more granular, detailed level of the site-specific review when there may be more information available to make those commitment decisions. And it allows this commission, not just the commission staff, to remain highly involved in the development of the CAP locations to ensure that the protections of public health, safety, welfare, environment, and wildlife resources remain at the forefront of development. So we did hear from several public commenters throughout the course of this process that posed challenges to both you as the commissioners and to Kerr-McGee as the operator requesting the CAP. Most, if not all, of those public commenters did not hold an interest in the CAP boundaries and therefore are voicing their continued concerns with the status of oil and gas development in Colorado. We feel that it's important to clearly state to the commissioners is that Kerr-McGee hears these commenters. It hears their voices, it hears their concerns, and acknowledges each and every one of those commenters has taken time out of their day and personal lives to bring their issues to this commission. What Kerr-McGee would like to provide in response is that it's working very hard each day in the state of Colorado and beyond to develop minerals in a way that not only drastically reduces the cumulative impacts to air, water, soil, wildlife, and humans, but to also uphold the new mission of the commission, which is to regulate the development and production of natural resources of oil and gas in the state of Colorado in a manner that protects public health, safety, welfare, including the protection of environment and wildlife resources. Kerr-McGee believes that the comprehensive area plan tool does just that, and that's why we're here today. So to conclude my opening remarks, Kerr-McGee has engaged and collaborated with the singular surface owner, mineral interest owners, other oil and gas operators, the Colorado State Land Board, CDPHE, CPW, Weld County, and the BLM on the proposed development and cumulative impact analysis of this proposed CAP. This continued engagement and consultation has resulted in this CAP application being unprotested and also supported by the director for approval by this commission. With significant stakeholder support, Kerr-McGee requests that the commission approve the Bronco CAP application and also confirm that Kerr-McGee has conveyed the rights set forth in Rule 314B 1, 2, 3, and 4 for the development of the CAP application lands, and specifically that the order confirm that Kerr-McGee has the exclusive right to develop the oil and gas formations that are subject to the CAP within the CAP's geographic boundaries for the duration of the CAP, that approved oil and gas development plans, drilling and spacing units, Form 2As and Form 2s within an approved CAP will not expire until the CAP expires, which in our case would be a request for 6 years, that Kerr-McGee need not separately evaluate cumulative impacts for the individual oil and gas development plan proposed within the CAP that would otherwise be required under Rule 303. And that's a reference to Rule 314B3. And then finally, that Kerr-McGee receive expedited review of associated oil and gas development plans pursuant to Rule 306D. So I'll say first off, thank you for your time and your consideration of this CAP today. I'm now going to share my screen and turn it over to Mr. John Cook and Mr. John Picara, who are going to give the presentation today. And then we'll also actually have testimony in the middle of the presentation from Mr. Mike Servey, the owner of Servey Ranch.
Great, thank you.
Thank you. Let me share my screen here. Okay, and Chair, can you see my screen okay?
We can.
Excellent. Thank you. So I'm going to go ahead and turn it over to Mr. Cook, who will kick off the presentation.
All right, hello and good morning. My name is John Cook. I am a reservoir engineering advisor with Kerr-McGee, and I have been involved in the CAP planning process from the beginning. I, along with my colleague John Picara, we're excited to present the Bronco Comprehensive Area Plan for your consideration today. We will be discussing a large number of topics as they are organized in the CAP rules, and after the presentation is concluded, we will have several subject matter experts available to answer any questions you might have. So Kerr-McGee Oil and Gas is one of the largest producers in the DJ Basin, and we have drilled thousands of wells. I'm not going to read all the slide to you, but I do want to emphasize that Kerr-McGee is committed to operating responsibly and being the partner of choice in Colorado. So Kerr-McGee is proposing a 24,331 acre comprehensive area plan that would cover the Codell, Niobrara, Fort Hays, and Carlisle formations. We're not seeking preliminary siting approval with this CAP. So in our planning, we have 11 conceptual oil and gas locations with a maximum of 209 new horizontal wells. This CAP is in rural Weld County, and all conceptual locations are more than a mile from any residential building units. We are seeking a 6-year term for the CAP, and no Rule 502 variances are requested. So preparation for this CAP began in October of last year and was filed in December. The completeness determination from the COGCC director was given in April, and the public comment period concluded on June 20th. We've held formal consultations with the CDPHE, the CPW, the BLM, and Weld County. And in June, we had a hearing for a stay of permitting with the commission that was approved. On July 5th, that was the petition date, and I would like to point out that no petitions were filed. Additionally, the comprehensive development plan pre-application process with Weld County was initiated on July 20th. So the proposed cap is in rural Weld County and bordered by Highway 34 to the north and Interstate 76 to the south. The existing spacing units remain largely undeveloped, and they will be modified in future OGDP submissions. There are 15 horizontal wells located within the proposed cap boundary. 13 of those are operated by Bonanza Creek, and 2, which were recently acquired from Verdad Resources, are operated by Kerr-McGee. There is an additional existing horizontal oil and gas location that is operated by Confluence DJ LLC that is located within the proposed boundary, but the wells from that location are, they extend outside of the cap. So in addition, there are 4 vertical wells within the proposed boundary, and all of these wells and locations were excluded from the Bronco cap application. So in compliance with Rule 314E A through L, all the required maps were submitted with the cap application and can also be found in the appendix to this presentation. So Kerr-McGee is seeking approval for a maximum of 12 wells per section on the west half of the cap and 10 wells per section on the east. We will be targeting 10 Niobrara and 2 Codell wells in the west and 8 Niobrara and 2 Codell wells in the east. Through careful planning and working with the surface owner, we've been able to consolidate our conceptual oil and gas locations down to 11 total locations. Most of these locations would be located along the existing utility corridor and road that runs down the center of the proposed cap. Based on the well density from the previous slide, we anticipate a maximum of 209 wells on these 11 locations to efficiently develop the minerals. At the time of the cap filing, Kerr-McGee had 2 existing locations within the proposed cap lands. These were evaluated for potential use, and it was determined that they were not suitable for full-scale development, and these locations will be plugged and abandoned and reclaimed once horizontal development begins. The Bronco cap is very significant to Oxy and to Kerr-McGee, and if approved, this project would be one of the highest priorities in our development schedule. If the cap is approved, we plan to begin submitting the first OGDPs within 6 months, and then we'll begin submitting Form 2 APDs as soon as the OGDP approval. Pipeline infrastructure will begin immediately following the approval of all appropriate state and local permits, and the expectation is to have pipelines completed to each oil and gas location before production begins. Similarly, oil and gas locations will begin being constructed soon after all the permits are approved, and we estimate that each location will take approximately 2 to 3 months to construct. After the locations have been constructed, drilling operations will commence. Our initial planning schedule has drilling beginning in early 2024, and drilling operations will occur on a 24/7 basis until all wells on the location have been drilled, and then the rig will move on to the next location. Completions operations will begin approximately 6 months after drilling has been completed on those individual locations. And similar to drilling, operations will occur on a 24/7 basis until the pad is complete, and then we'll move on to the next location. Immediately following completions, the wells will begin flowing through the pipeline infrastructure to the sales point. The production phase for each well is estimated to last for about 30 years or longer. And once it is no longer beneficial to operate the well, the plugging and abandonment phase will begin, where all surface equipment will be removed and the site is reclaimed to its original state. Kerr-McGee owns approximately 60% in the Bronco cap, and Civitas through Bonanza Creek owns approximately 37%. After our recent trade with Verdad, they own approximately 2% of the cap, and all other leasehold is about 1%. For mineral interests, about 78% of the minerals are fee minerals, 21% are state minerals, and 1% are federal. It's also worth noting that we have received a letter of support regarding the Bronco cap from Hobie Minerals, which is a large mineral interest owner within the cap. As for the surface, 79% of the cap lands is fee surface, and it is one singular surface owner. State lands make up 21%, and less than 1% of the surface is federal. We recently completed a surface use agreement with Survey Enterprises, which is the only private surface owner within the proposed cap boundary. The surface use agreement was a very collaborative process with Survey Enterprises. And through our discussions, we were able to consolidate our original plan of 19 locations down to 11 and consolidate infrastructure into one main corridor. And now, Mr. Mike Survey, who is the majority surface owner of the CAP, he would like to say a few words.
Great, thank you, Mr. Cook. And Chair Robbins, I'm going to just confirm that I can see Mr. Survey.
Yes, Mr. Survey, we can see you. Welcome. We are happy that you're with us. Would you like to provide a statement?
Yes, and Chair, I'm going to ask Mr. Survey a few questions as we go through this. It'll be a little bit more like some question and answer testimony, just for purposes of going through his testimony today.
That's fine.
So great, thank you. So again, good morning, Mr. Survey. Can you please provide your full name and company name to the commission?
My name is Mike Survey. I own Survey Enterprises. I live at 12311 Weld County Road 386 in Weld County at Roggen, Colorado.
Excellent. Thank you, Mr. Survey. And can you please tell the commissioners a little bit about your family's ranch?
I bought this ranch in 42 years ago. I'm a rancher that was raised at Stoneham, Colorado, north of Stoneham. My grandfather homesteaded that ranch in 1872. I've been in this area all my life. I have two boys at the age of in the mid-30s. They work on this ranch and they have other things they do. We've grown up around cattle and ranches all of our lives. It's basically our whole living is raising cattle and livestock, and that's my whole background.
Thank you, Mr. Survey, much appreciated. And have you testified in front of the commission prior to today?
No, ma'am, I haven't.
Okay. And I'd like to confirm you have not been paid to be here today, correct?
No, ma'am.
Okay. And are you familiar with the Kerr-McGee's comprehensive area plan up for review by the commission today?
Yes, ma'am, I am. I've been going over it now and visiting with David Hartel, one of their people. We've worked on this thing a long time to make both parties satisfactory the way they're going to do it. This ranch lays next to a ranch called the Gutterson Ranch. It's 39,000 acres. Our ranch is approximately 60,000 acres. It combines almost 100,000 acres of land in one spot. And Art Gutterson, who's my neighbor, we're very close to each other. They have children that were raised with my children. We've agreed that we would, it's one of the few spots in this area close to Denver of this size. We're already feeling and seeing more wild game and wildlife coming on ranch because we've combined both ranches and we've kept everybody off of it. We've taken the pressure off of it. We can see now that it's beginning to pay off. Art has turkeys. We're getting more pronghorn and deer than we've ever had. And my boys are excited about it. I was not agreeable or favorable to a development of this kind on this ranch because I grew up on a ranch and we've never had any oil and gas development on our ranch or the Stoneham Ranch. We feel like we want to stay that forever, stay that way. As y'all know, times are changing and we see it coming. So the boys and I have agreed to make a deal with Chevron Occidental. Chevron talked to us, but Kerr-McGee, they call it, Oxy, as far as we're concerned. We know they have the money to develop and do it. They've guaranteed us they would go down one pipeline road or one road called Powerline Road, where it's all in probably about a 30, 40 feet wide road, goes straight through the ranch. It doesn't bother any more of the ranch. We developed it to So we'd get the ranch and we would gather cattle. We'd go down that road and go to wherever we wanted to with very easily. We feel if we're going to do this, we have the best company for what they have offered us and given us. And I can't say enough, if we're going to do it, that we're on the right track.
Great. Thank you, Mr. Servey, for that. And have you executed a surface use agreement with Kerr-McGee?
Yes, ma'am, I have.
Okay. And does that surface use agreement require specific sites for Kerr-McGee's 11 oil and gas locations on your ranch?
Yes, ma'am, it does.
Okay. And are any of those 11 oil and gas locations within 2,000 feet of your home?
No, nothing. This is a branch of 60,000 acres. There are not any homes but our own home in that area. And Art Gutterson's, probably 7 miles to the west. There aren't any homes within this. 2 homes are within this 100,000 acre plot of ground.
Great. Thank you, Mr. Servey. And you have other oil and gas operator well pads on your ranch, correct?
Correct. It'd be, well, they call it Civitan now. Used to be Bonanza.
Okay, great. And will the development of the CAP and Kerr-McGee's 11 oil and gas locations interfere with those existing locations?
No, ma'am, they would not.
Okay, great. And then really just, I want to thank you for your comments and your being here today. We know you have a ranch to run. So I'd like to just ask you if you have any other comments you'd like to provide the commissioners about Kerr-McGee's CAP development on your ranch.
Well, no, they could ask me anything they want to. We've been very successful ranching. We love it. We have children involved. It's our way of life. And obviously I wouldn't like any development on the ranch, but I'm not sure that's the end answer in years to come. I think these 2 boys can work with this. They're aware of all this. I'm not a big fan of the development of oil anywhere, but this large ranch could be the thing with this company. Let me put it this way, I'm more comfortable with this company than I am all the companies that have been honest, that have been bankrupt. It's that simple.
Great, thank you, Mr. Servey. And Chair, we do have limited availability for Mr. Servey, so he won't be able to hang on to kind of the end when we do the normal kind of question and answer with all of the subject matter experts. So if I may be so bold to ask you or the commissioners if they have any questions of Mr. Servey now, we would greatly appreciate it. And again, let Mr. Servey go back to the business of running his ranch.
Yeah, that's fine. Mr. Servey, thank you very much for being with us today. I recognize that testifying to the commission is probably the last thing you wanted to do today and that you'd rather be out on your ranch. But we do appreciate your testimony today, your honesty. I also would note that all of the commissioners have read the letter that you sent to us in support of this comprehensive area plan. And we appreciate the fact that you took time out of your day to provide that letter of support. With that, I'm looking around to see if any commissioners have questions for you. Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Mr. Servey, for being here today. We don't really often get to meet the surface owners, and so it's nice to hear this perspective of your experience. And I was wondering if you could just share, for the record, if you had any concerns about how this development was proposed, or how the company worked with you to address any concerns that you had with this proposal and how they were addressed.
No, they, between us, we know this is not necessarily the simplest, but it makes more sense of a ranch of this size to come down that power line road and not disturb all the rest of these ranches. I watched some adjoining ranches where they had no really good plan, and they've ruined that ranch. I owned it years ago, and what I've seen happen there disappointed me. So when they came to me, they were aware of what I'd seen and what I didn't want to see. And they came up with this development to go down this road, which keeps all the traffic on one road. It departs on 34, which is not a highly traveled road. I don't know of a better way to develop this particular ranch if I were to do it myself. I've watched too many ranches be ruined by oil companies that didn't use the surface owners' either advice or they could do what they wanted. Here I'm more or less in the driver's seat of the development, with I meaning that only by the development of the land above. I know nothing about the gas and oil business. But with that said, I don't know that all ranchers have been fortunate enough to have the opportunity to develop the ranch where I feel is the best for what they want to achieve. And also, Art Gutters and I are very, very strong on what the future is of a ranch this size, 40 miles from Denver. What happens to the wildlife and the game? There's not many ranches like this within 40 miles of Denver. And obviously, he and I both would like to see it be maintained as it is. And I'm sure this the only way it could have been done. They want 11 pads. I've seen them do a lot worse in other places. Not this company, but I've seen the oil development in other areas on ranches not be developed to the best of the ranch.
Thank you for coming today and sharing your experience and testifying.
Thank you.
Commissioner Cross.
Thank you, Chair Robbins, and thank you, Mr. Servi, again for your time and your testimony today. And I do appreciate what you were saying about being able to use that road and that you have already to try and minimize any disturbance to your ranch. Do you have any concerns with the different pipelines coming in and being used along that same route as well?
No, if they have agreed to keep the pipelines on that road, obviously to discharge the products, they're going to have to go off that road. And I understand that. I don't know if they're fully aware or sure of where they're going to get rid of the oil and the gas, but they've the way the SUA is set up, I can more or less not designate, but we can make it simple to get off that ranch with a product. And that means a lot because there's less traffic.
I appreciate that. Thank you.
Are there any further questions for Mr. Servi? All right, Ms. Jost, I'm not seeing further questions. Thank you again, Mr. Servi. We appreciate your being in attendance with us.
Thank you, and I appreciate you all listening to me. Thank you.
Thank you, Chair. Thank you, Mr. Servi. And Chair, with that, we're going to go ahead and have John Piquera take over for the remainder of the presentation until we get right to the end.
Very good.
Thank you, Jamie. Good morning, Commissioners. My name is John Piquera. I'm a regulatory advisor. I've been involved since the beginning of planning of the CAP and also the submission of the CAP application. Thanks for your time today. For purposes of evaluating cumulative impacts, we assume the max case scenario of 209 wells, 11 oil and gas locations, and 1 compressor station. We're willing to work with staff to have the cumulative impacts data incorporated into the cited database. COGCC is evaluating the possibility to use produced water gathering, but it's not able to commit at this time, being we're still in discussions with a third party to determine the feasibility. We have 4 existing locations and 4 wells within the CAP. 2 locations and wells were recently acquired from another operator. We anticipate plugging these wells once new production is established and reclaiming that land. There are several other wells and locations within the Bronco CAP, but generally these lands are undeveloped for oil and gas. COGCC is committed to numerous air-related BMPs in the Bronco CAP application, and several of those proposed by CDPHE. A couple of those BMPs include performing air monitoring during drilling, completions in the first 6 months of production. We'll use a closed loop system for flowback. We're going to eliminate carbon storage on location and the associated truck loading, and using a new facility design that reduces the number of separators on location, thereby decreasing our footprint overall. We conservatively estimated total emissions over a 35-year life of the wells and facilities within the CAP. The table on the screen shows the totals. Additional BMPs may be implemented, which further will reduce those estimates. COGCC has been performing air monitoring around pre-production and production facility operations since 2018. Over 4,000 air samples have been collected and analyzed for benzene and other hazardous air pollutants, which have been accepted by the CDPHE on a consistent basis. Results of all of those validated samples have been below health guidance values compiled by CDPHE. The analytical results collected to date are representative of pre-production and production facility operations for the proposed facilities in the Bronco Cap. Based on the results of the air monitoring done to date, the proposed facilities in the CAP are not expected to emit air pollutants at a level that could negatively affect public health and safety. There's minimal support for repairing corridors, wetlands, or surface waters within the CAP boundary. The visible vegetation changes indicate potential concentration areas for stormwater and topographic depressions. Potential freshwater emergent wetlands have been identified within the CAP boundary using aerial imagery and National Wetland Inventory spatial data. The 3 conceptual oil and gas locations in the southern portion of the CAP are adjacent to National Wetland Inventory mapped wetlands. These locations were surveyed by a third party, and it was determined there's no hydric soils and the vegetation is likely non-persistent. Therefore, no true wetlands exist there. Although unlikely, if wetlands are identified near other locations, efforts will be made to avoid them. Stormwater BMPs will be implemented, controlling the flow of runoff from our locations. As Jamie mentioned earlier, there's also no public water system wells or surface water intakes within the CAP boundary. Pre and post drill water samples will be taken from applicable water wells pursuant to Rule 615. 9 of the 11 conceptual locations and the compressor station are within pronghorn winter concentration area high priority habitat. Being that approximately 80% of the application lands are within this HPH, alternative locations would probably fall within the HPH as well. Alternatives to develop the same mineral acreage would also likely be further away from the existing central road and utility corridor Mr. Serby spoke about, thereby increasing fragmentation within the HPH. Bald eagle winter night roost and aquatic native species conservation waters are both within 1 mile of the CAP boundary, but the nearest location is well over a mile away. No locations will be sited north of Highway 34, therefore avoiding habitat adjacent to the South Platte River. Currently, a full environmental assessment is ongoing, and to date, no raptor nests have been identified near any locations. As mentioned earlier, the 3 southernmost locations have been assessed for the presence of wetlands, and it was determined none exist. A full list of wildlife BMPs are outlined in the CAP application. Soils within the Bronco Cap are generally well drained and have low runoff potential, indicating there's minimal possibility for impacts associated with erosion and sedimentation. Topsoil will be segregated prior to construction and seeded. The only vegetation and topsoil that will be disturbed is that area necessary for construction of facility locations. The Bronco Cap's in a rural setting with no residential building units, schools, school facilities, or childcare centers within the application lands. Locations are planned to be 1 mile or much further from residential building units. Traffic will avoid county roads and residential streets and be contained within the Bronco Cap and Highway 34. We've had initial outreach to CDOT regarding an access permit. At this time, COGCC doesn't plan to utilize sound walls or odor reducing additives due to the distance from residences. Lighting and dust plans will be submitted with individual OGPs, and it's anticipated there's going to be no adverse impacts to public welfare from the proposed development. You can see on this map, the nearest disproportionately impacted community is well over 6 miles away from the CAP boundary. Pipelines are anticipated to be primarily located along a north-south central corridor, co-located with existing roads, pipelines, and other utility infrastructure. Construction will likely begin immediately following approval of applicable permits. Now, we had some discussion earlier about BMP, so I'd like to touch on that now. Kerr-McGee is committed to 44 BMPs in the Bronco Cap application in the Exhibit 4. In late May of this year, CDPHE provided Kerr-McGee with a spreadsheet of BMPs and asked which we could commit to at the time. In coordination with CDPHE, Kerr-McGee was able to commit to 37 of those BMPs. And we'll address any additional site-specific BMPs at the OGDP stage for those individual locations. A letter from Mr. Coffin at CDPHE summarized those BMP commitments and has been attached to this presentation as supplemental slides. There is some overlap between the Exhibit 4 and the spreadsheet, but those 50 plus BMPs are firm commitments, not BMPs we will aim to implement or just consider. The BMPs we commit to here will not be meaningless and will carry through to the OGDP stage. We also commit to consider another 20 or so BMPs on CDPHE's spreadsheet. At the end of this presentation, I'd be more than happy to read through all BMPs we commit to and those we're still evaluating. We appreciate the open communication and coordination with CDPHE and look forward to future discussions. On this slide and the next, Kerr-McGee attempted to group the majority of those BMPs, which we have committed to, into categories of avoid, minimize, and mitigate for the various cumulative impact criteria. Those bolded BMPs are those which were proposed by CDPHE and we have agreed to. Understanding you've had an opportunity to review this presentation prior to the hearing, I won't go through each of these, but we'll be happy to answer any questions at the end. This slide shows the BMPs for the 4 remaining cumulative impact criteria. Throughout the past year, Kerr-McGee staff has had conversations with multiple stakeholders, including COGCC staff, Weld County's Oil and Gas Energy Department, other state agencies, serving enterprises, and mineral and working interest owners. In cooperation with COGCC OVLA staff, we conducted consultations with Weld County, OGED, CPW, CDPHE, and the BLM in June of this year. We welcome ongoing communications with stakeholders throughout the life of our operations. As Mrs. Trask mentioned earlier, during the public comment period, 114 comments were submitted. None of these were from interested parties. Kerr-McGee provided responses to COGCC on July 6th of this year. Many of the public comments were regarding emissions, air quality, wildlife, and water resources. Kerr-McGee aims to reach net zero emissions associated with our operations before 2040 and net zero emissions associated with the use of our products by 2050. This is in line with the state of Colorado's target of reducing emissions by 90% by 2050. We've achieved zero routine flaring in Colorado for many years. We conduct air monitoring and have been since 2018. Reports are sent to CDPHE and are also posted to our website. We use a facility design which eliminates hydrocarbon storage. We use compressed air instead of natural gas for pneumatic controllers and use a closed loop system for completions. Kerr-McGee will work closely with CPW to mitigate any impacts within HPH. And as I mentioned earlier, 3 of those locations in the south were surveyed for wetlands and none were present. And also we'll survey elsewhere and likely none will be found, but our goal is to avoid them being found. In Colorado, the oil and gas industry generates approximately $1 billion annually to state and local governments, which funds schools, parks, and roads across the state. Kerr-McGee's Integrated Operations Center, or IOC, monitors our locations remotely 24 hours a day, 7 days a week. The IOC staff has the ability to shut in wells remotely and dispatch personnel to location if they detect a potential issue. Our stakeholder relations team is available to contact with any questions or concerns. Their number, email, and website are on this slide. Having a single operator over these 24,000 plus acres allows for further reduction of cumulative impacts by consolidating our infrastructure to the greatest extent, utilizing and co-locating locations, roads, pipelines adjacent to existing infrastructure and disturbance, and being able to evaluate reclaiming existing locations. On May 9th, Kerr-McGee sent invitations to a public meeting to 29 interested parties. In the invitation, we also offered to meet and discuss and provided a link to our website with further details about the Bronco Cap. We did not receive any calls or emails with questions, and four individuals registered for the meeting. The meeting was held virtually on May 23rd. 2 individuals who registered attended. No questions were asked during the meeting. As also mentioned earlier, we received 2 letters of support for the development of the cap. These were from a significant royalty owner, Kobe Minerals, and also the service owner, Servi Enterprises. Since late 2021, there has been continued outreach to the State Land Board through meetings and multiple email communications. The State Land Board has expressed they do not object to the Bronco cap. During the public comment period, Kerr-McGee, in cooperation with COGCC OGLA staff, had consultations with Weld County Oil and Gas Energy Department, CPW, CDPHE, and the BLM. On June 9th, we met with Weld County. During that time, Weld County expressed support for the CAP development plan. During the meeting, Kerr-McGee provided an overview of the development plan, addressed current and future land use, and described the traffic estimates during different phases of operations. Other topics of conversation included coordination with CDOT for an access permit, existing right-of-way within the CAP, consolidation of infrastructure, and plans for utilities. Weld County briefly touched on their comprehensive drilling plan, or development plan, and the 1041 WOGLA permitting. As John mentioned earlier, Kerr-McGee has already begun Weld's CDP process and held a pre-application meeting with Weld Oil and Gas Energy Department, their public works staff, OGLA staff, and CPW on July 20th. On June 16th, Kerr-McGee had a consultation with CPW. The main point of conversation was around the Pronghorn Severe Winter Range, HPH, being a large portion of the Bronco cap is coincident with this boundary. We communicated to CPW that our operations are planned to be continuous through full development, and we will work with staff to establish mitigation fees as required. CPW questioned whether we plan to add additional locations in the future and if it was possible to consolidate locations further. There's no intention to come back with additional disturbance in the future, and our locations have been consolidated likely to the maximum extent possible. We also described to CPW that in the early stages of development planning, we contemplated up to 19 oil and gas locations. Ultimately, we were able to consolidate and eliminate 8 of those locations. Due to technical limitations and to conduct operations within limits that are proven to be safe, we believe we've consolidated to the maximum extent possible to develop the minerals within the cap. Kerr-McGee looks forward to continuing the communication with CPW and consulting again at the OGDP stage. On June 14th, the consultation with CDPHE was held. As discussed earlier, CDPHE had provided Kerr-McGee with a list of BMPs and had asked for us to provide feedback about which we could commit to at that point of the process. Kerr-McGee returned the spreadsheet to CDPHE prior to the consultation. We identified those BMPs we could commit to and those we would continue to evaluate while working towards submitting OGDPs. Following the meeting with CDPHE, we were asked for further details regarding our qualitative evaluation of public health and air quality analysis. We had responded a few days later. Kerr-McGee anticipates having further open communication with CDPHE prior to submitting OGDPs. And the final consultation was also held on June 16th with the BLM. BLM did not have any objections to the CAP development plan. BLM requested we have further discussions with staff regarding any of our planned wells offsetting federal minerals outside of the spacing units we propose. They want to ensure adequate setbacks are maintained. A couple other topics of discussion included the likelihood of meeting federal APDs, the average number of wells per pad, if natural gas would be produced, would Kerr-McGee flare, produced water disposal options, number and size of spacing units, and the status of other wells currently within the CAP boundary. COGCC will continue discussions with BLM once the wells are planned and will pursue federal APDs as necessary. Now I'd like to turn the presentation back over to Jamie. Thank you.
Great, thank you, John, much appreciated. And before we kind of wrap this up and then hit the commissioner questions that were provided, we would again really like to take a minute and provide a sincere thank you to the commission director, this commission, deputy director, the staff, Jason Maxey, Jennifer Teeters, CDPHE, CPW, State Land Board, Mr. Servey, and all the working interest owners in the CAP. There have been countless hours of discussions, questions, evaluations, and analysis that have gone into this CAP from all of those stakeholders. And COGCC is very appreciative of everyone's efforts. The director's recommendation recognizes the collaborative efforts of numerous groups of people, agencies, and companies, and has recommended approval of this CAP today. COGCC respectfully requests that the commissioners give significant weight to the director's recommendation and the analysis of the CAP in the deliberations today. And what I'd like to do now is address the 16 commissioner questions that we did receive throughout Monday and Tuesday and provide responses for your considerations. I'm going to ask all of the subject matter experts we have from COGCC to turn on their cameras, and then we'll walk through each of these individually, Chair, if that suits the commission.
That would be great.
Okay, and we may, just as a heads up, I may pull the screen share back up just so we can walk through some of these, but I think in order to see everyone, I needed to go ahead and take that down, and we'll utilize it accordingly. All right, looks like we have everyone. Thank you. We have a whole host of subject matter experts here. They will address their names and title as they address the questions. And I'm just going to start with question 1, and we'll go through section 16 and hit each of these individually. So to Mr. Cook, what does anticipates electric infrastructure for the entire CAP area mean? When will COGCC know if this is part of the plan or not? And how are these potential emissions addressed in the cumulative impacts analysis?
Yeah, thanks, Jamie. So electric infrastructure is required to power the equipment on our production facilities, and in Exhibit 4, COGCC committed to using electric compressors for our gas lift production system, and that is our current plan. So emissions estimates and cumulative impacts analysis assume that facilities will have electricity at startup, and it doesn't factor in emissions for any supplemental power generation.
Great, thank you, Mr. Cook. And now to Mr. Reamer. What are COGCC's thoughts about staff's suggestion to create a region-wide wildlife plan?
Thank you, Jamie, and thank you, commissioners. My name is Joseph Reamer, and I'm an environmental advisor with OXY. Our thoughts are that a region wildlife plan makes a lot of sense in this area. This is something that we are currently working with Colorado Parks and Wildlife to understand the expectations and requirements. While we can't commit to adopting a region-wide plan today, we will commit to continue to have those discussions with Colorado Parks and Wildlife during the OGDP planning process to determine if it may be a useful tool for the protection of wildlife in the CAP area.
Great, thank you very much. And Mr. Cook, when will COGCC know if produced water can be piped away from these locations? Am I reading the traffic chart correctly that produced water piping versus trucking produced water away is a difference of approximately 50,000 truck traffic miles for the life of the wells?
So that's correct. By piping produced water, we expect to eliminate over 50,000 truck trips. COGCC, we're currently in negotiations with a third party regarding produced water gathering. We anticipate a final answer on produced water before the CAP OGDP submittals, and we'll address the produced water pipelines with commission staff during the submission of the OGDP applications.
Great, thank you very much. So moving on to Mr. Hess. COGCC is evaluating the need to utilize gas lift technology at the wells. In the development is if COGCC elects to use gas lift, the associated compressors will be electrically driven. The use of electric compression instead of natural gas driven will substantially reduce potential emissions from the development. Can Kerr-McGee explain the difference in emissions if gas lift with electric compression versus natural gas? And what assumption is in the cumulative emissions chart?
Thank you, Jamie, and hello, commissioners. My name is William Hess, and I'm an air quality engineer. On page 15 of Exhibit 4, Kerr-McGee has committed to using electric compression for gas lift and did not evaluate a scenario where natural gas-driven compression was utilized.
Great, thank you, Mr. Hess. And Mr. Cook, back to you. Kerr-McGee will consider decommissioning 2 existing locations on the property. At what point will Kerr-McGee know if this is the case?
Yeah, so once new production is established in and around the existing locations, these 2 locations will be plugged and abandoned and reclaimed. Additionally, the horizontal wells that we recently acquired from Verdad Resources will also be plugged, abandoned, and reclaimed once production is established.
Great, thank you very much. And the next question stated that I'm appreciative that the operator followed the requirements of Rule 314 and provided as reflected in the rule. In hindsight, it may have been more apples to apples if the commission required a Form 2B so we can reflect emissions to the CIDR database as well as have information collected uniformly to an OGDP application. How will we ensure cumulative impact data from this application can actually be utilized as part of the CIDR data collection and as part of our annual cumulative impact report? Will the operator follow up and provide landscape data that can be compared to the application, or will we have to add up individual OGDP data for assessment and comparison? So I'm just going to hit on this one because Sabrina did a wonderful job of answering your questions on the Form 2B, the CIDR data, and how that works into the annual cumulative impacts report. And we also have had some of those initial discussions with the commission staff about how this detailed cumulative impacts analysis data will transfer to the CIDR data and that cumulative impacts report. So from the standpoint of Kerr-McGee's aspect, well, that question was probably better addressed by staff that Sabrina has already talked about. Kerr-McGee will commit to working with the commission staff to ensure that the appropriate data from the Bronco CAP cumulative impacts analysis is included in the CIDR data, regardless of kind of what form that takes. And they'd be happy to continue to work with staff on developing the submission of that data as it proceeds through the proper processes. So back to Mr. Hess. If not using electrical power for drill rig, can Kerr-McGee provide comparison of actual emissions from using electric drill rig versus Tier 4 engines? Is Kerr-McGee planning on using all diesel engines, some natural gas? I think this is the same operator that presented on their new battery technology for drilling. Am I remembering correctly? Is it possible to use the battery here to reduce emissions? I understand that electrification is not being considered here, but I would like to see what considerations were made to decide what kind of engines to use and emissions comparisons. What assumption is in the cumulative impact data? All diesel emissions?
Thank you, Jamie. For the purpose of analysis and in order to be conservative, Kerr-McGee assumed a combination of diesel and natural gas engines for drilling and completion rigs. In our response to CDPHE, we have committed to using natural gas engines for our drilling rigs for the development. Further, and just to be clear, it was noted in the CDPHE letter to the COGCC that Kerr-McGee did commit to considering the use of electrical drilling rigs on the CAP locations, so this is still a possibility. Kerr-McGee has undertaken a formal power study to determine whether electrical power is available and sufficient in this remote area. So Kerr-McGee will absolutely consider the use of electrical rigs for the CAP development. However, because we cannot commit to electrical rigs right now for reasons that we have already discussed, we included assumptions for a combination of natural gas and diesel engines for drilling and completion rigs. We agree that electrical engines will result in fewer cumulative impacts, and if that is the case where they are used, the emission calculations in our analysis will be reduced during development.
Great, thank you, Mr. Hess. And to Mr. Honus, can Kerr-McGee talk about Group 3 drilling mud? In addition to odor reductions, do Group 3 muds have fewer VOCs and therefore fewer emissions? What are emission comparisons to Group 3 drilling muds as requested by CDPHE versus the mud proposed by Kerr-McGee?
Yeah, so our game plan would be to use the mud system that we're currently using in our operations within the DJ Basin. This is not a Group 3 drilling mud. This is a combination of a Group 1 and a Group 2 drilling mud along with water. The combination of the three we've been monitoring on our sites within the DJ Basin for the last couple of years now, and it indicates that the VOCs are very, very minimal off-site. From an odor standpoint, we would be able to use an odor neutralizer if odors did become an issue. However, with the area of this particular cap, with no one within 5,000 feet of the rig, we don't anticipate the need for odor neutralizer, but we have found that this is a very effective method should odor become any issue while drilling.
Great, thank you, Mr. Honus. And just for the record and everyone on here, can you please let them know your title with Kerr-McGee?
Yeah, sorry, Chris Honus, drilling manager for Occidental.
Great, thank you so much. And then the next question is, are the petitions from Verdad and Bonanza Creek all worked out? I think I see that Verdad pulled theirs in the e-filing system, but did not see the same for Bonanza. And I'm going to go ahead and answer that question. Yes, the petitions that were originally, or I should say against the originally published notice of hearing for the stay are no longer valid and are moot. As you may recall, the commission staff issued a notice of hearing to stay prior to the director's determination of completeness. So that notice of hearing was determined moot, and they issued a new notice of hearing for the stay that was sent out in April. So the second and valid notice of hearing was sent to all parties in the end of April in 2022, including Verdad and Bonanza Creek, and neither party petitioned the stay, which proceeded to an uncontested approval of the stay in front of this commission in June. Also in April 2022, the commission staff issued the formal notice of hearing for the hearing today, August 3rd, and the petition date for the cap was July 5th, and neither Verdad nor Bonanza Creek submitted petitions challenging the cap. Although Verdad did withdraw their petition from the system, it was not required to do so because it was determined moot, because it was submitted against a basically a non-effective notice of hearing. And also, as you heard today, Kerr-McGee did acquire Verdad's wells within the cap boundary and also a portion of their interests, which results in Verdad no longer having operations within the cap boundary. Kerr-McGee has also engaged in continual conversations with Civitas about the cap, and those conversations will continue to be ongoing as the cap development proceeds. And again, no petitions were filed by either Civitas or Verdad today. We would be having a much different hearing if that would have been the case. So, Mr. Hess, I'm going to come back to you for the next question. What is happening in years 31 to 35 for emissions to drop so much? Is this because wells are beginning to be P&A'd? On table 1, isn't the production for these kinds of wells in the first 6-ish years? And so starting around year 7 and 8, would we see a slow decline in emissions merely by the fact that less is being produced? And the same question goes for table 2.
Thanks, Jamie. That is correct. Emissions begin to drop in year 31 due to the beginning of P&A operations. While oil production undergoes a slow and steady decline, water production declines at a sharper pace, and by approximately year 3 of a well's operations, we anticipate that the produced water rate to be flat year over year for the life of the cap. Kerr-McGee has committed to not setting oil tanks at the proposed facilities, so the slow and steady decline from oil production will not factor into the cumulative impacts emissions.
Great, thank you very much. And back to Mr. Reamer. The development will take place largely within pronghorn winter concentration area, high priority habitat. As the intent of the cap is to comprehensively address impacts and devise mitigated strategies, why does the cap not make mention of the standard primary wildlife impact reduction method of minimal to no development activity during the sensitive pronghorn wintering season of January 1 through April 30?
Thank you, Jamie. Sorry. We continue to explore all our BMP operations during this collaborative planning process with Colorado Parks and Wildlife. This specific BMP will be discussed with Colorado Parks and Wildlife during consultation. We continue to review our schedule flexibility internally, and as we gain clarity throughout the approval process, we may be able to adjust our schedule accordingly.
Great, thank you very much. And back to Mr. Hess. Kerr-McGee will be utilizing new facility designs that reduce the number of separators required at a facility by 66%. Separators are equipped with natural gas heating elements, and therefore this reduction in separators will result in a 66% decrease in combustion emission from heaters. Can Kerr-McGee talk about this in their presentation? This sounds really interesting.
Yes, so due to a change in well testing and measurement processes, Kerr-McGee will tie more wells into a single separator and therefore reduce the number of separators needed per well at each facility.
Great, thank you. And sticking with you, Mr. Hess, in the application, there are a number of proposed BMPs that are not firm commitments. For example, produced water takeaway, oil takeaway, gas lift technology, and electrification of rigs and operations. When developing the quantitative cumulative impact analysis for water, wildlife, public health, etc., did they assume that there would be oil, produced water, electrification as part of the operations or not?
So Kerr-McGee committed to not having oil storage tanks at the proposed facilities, and therefore emissions from oil storage and trucking are not included in the quantitative assessment. Emissions estimates in the cumulative impacts assume that facilities will have electricity at startup and do not factor in emissions from any supplemental power generation. Kerr-McGee is still evaluating pipeline takeaway for produced water, and therefore the cumulative impact analysis included emissions from produced water storage and trucking.
Great, thank you very much. And to Mr. Picara, did the quantitative analysis evaluate offset impacts associated with potential plugging and abandonment and reclamation of existing sites?
In the traffic section of the cumulative impacts analysis in our Exhibit 4 with the application, we documented that truck traffic is estimated to be reduced by approximately 110 truck trips annually, and that's between the two locations once those wells are plugged. Additionally, in Exhibit 4, we indicated that the plugging of those two existing locations would return roughly 4 acres to pre-existing conditions. Those two locations that we evaluated are also in HPH. The emissions reductions, however, were not accounted for in the analysis, but it's anticipated the beneficial impacts from an air perspective will be minimal, being these wells are low producers. To date, and at the time of submitting the application, we had not acquired those other two newer locations. So at this time, we haven't performed an analysis on those acquired wells and locations, but it's anticipated that it'll be similar to the other two that we evaluated as far as beneficial impacts.
Great, thank you. And to Mr. Reimer, Rule 314A1, which lays out the purpose of a CAP, indicates that the intent of the CAP is to facilitate evaluating and addressing cumulative impacts from oil and gas development in a broad geographic area. Understanding this, I'm struggling with some lack of firm commitments and specifics within the cumulative impacts analysis within the application, particularly around wildlife impact analysis narratives and plans. Is the intent to provide a wildlife mitigation plan for the entire CAP or to develop specific plans per OGDP application?
Thank you, Jamie. We are working through the decision process on whether a comprehensive wildlife plan or individual mitigation plans by OGDP make the most sense. We have a field meeting with CPW on Friday to discuss several of these topics related to the CAP and actually show them the habitat in the field. At this point in time, the comprehensive wildlife plan covering all the locations within the HPH makes the most sense. As far as mitigations, we are currently discussing those internally and plan to incorporate feedback from our discussions with CPW into our mitigation list. Those will be submitted as part of our wildlife mitigation plans.
Great, thank you very much. And then the final question back to Mr. Picara. In addition, can you please provide a breakdown of all proposed BMPs into two categories? The first category being BMPs that are firm commitments, shalls, and the other being BMPs that you will consider or will try to do, mays.
Thanks again. To revisit what I mentioned earlier, in Exhibit 4, starting on page 14, we summarized those 44 BMPs we were to at the time and are still committed to. CDPHE provided us with a list of BMPs prior to our consultation and asked which of those we could commit to at the time. 37 of those we agreed to, a couple we could not, and a few of those were just not applicable to our CAP or our operations. Those remaining 18 we are still evaluating. We'll have a firm answer on those when we file OGDPs. There's some overlap between those BMPs committed to in the Exhibit 4 and CDPHE's list, but we're committing to over 50 currently, which Kerr-McGee often implements as standard practice. Again, all of those commitments to BMPs are firm. At this time, I would be happy to read through the list of BMPs in Exhibit 4 and those we have committed to in cooperation with CDPHE if any commissioner would like. I could also read those which we are still evaluating. Attached to this end of the presentation in slides 53 and 54 is a letter from Mr. Coffin at CDPHE, which summarizes those BMPs.
Great, thank you, Mr. Cara. And Chair, that wraps up the questions, but we would be happy to go through each of the individual BMPs for the commissioners who have those questions, if that's something that the commissioners would like to do before we wrap up.
Commissioner Messner.
Thank you, Mr. Chair. That was my question, so I can address that. I'm happy to address that as an individual question on specific ones, because even in the ones that I think you think that you're committing to, the language in those BMPs is squishy enough that it's unclear what that level of commitment is or what it is. And so I'm just trying to create clarity for the record, so that both the operator and staff understand what is being committed to and some of the language associated with that. So I'll address that with a question further along. I've got some specific examples.
Okay, great. Thank you, Commissioner Messner. And when we hit that stage, I'd be happy to pull up specifically the CDPHE letter that delineates the commitments versus commit to consider if we need to, or even Exhibit 4 if we need to. So let us know. And so really with that, that concludes our presentation. Kerr-McGee does request that the commission recognize the CAP as a culmination of several months of preparation, work, and intensive analysis, as well as thousands of hours dedicated to the development, structuring, outreach, and finalization of this application. And we also respectfully request that you approve the Bronco CAP and that the commission's order confirms the rights set forth in Rule 314B1, 2, 3, and 4, and that those rights are conveyed to Kerr-McGee for the development of the CAP lands. So again, thank you for your time and consideration of this application today, and we still have all of our panelists available to answer individual commissioner questions.
Great, thank you, Ms. Jost. Thank you for proactively answering questions that were previously submitted by our commission to you. That's helpful to sort of kick off the next stage of this matter, which is commissioner questions. Commissioners, I anticipate we're going to have some questions. It is 11:45-ish. Do you want to go straight into questions, or do you want to take a short break and then come back after having looked at your notes? What are folks' thoughts? I could go either way. Does anybody have any? And I've got like a gazillion people on the screen right now, so it's hard to see people. Commissioner Messner, I think you raised your hand.
Thank you, Mr. Chair. I would prefer to have perhaps even a short lunch break now, go over notes, and then be prepared for questions after lunch, seeing it's 11:45.
Okay. I think I probably am fine with that. Why don't we do that? Let's come back at 12:30. It gives us 45 minutes. Ms. Jost, if your folks could remain by, we'll have questions starting at 12:30.
Absolutely. Thank you, Chair.
Okay, this is Colorado Oil and Gas Conservation Commission. It's 12:30. It's August 3rd. We are returning from our break. We are considering the Bronco cap for Care McGee Oil and Gas Onshore LP. We're at that stage where we have potential for commissioner questions, but I'm going to suggest to my fellow commissioners that let's talk amongst ourselves for just a bit here first to kind of gauge kind of where folks may be. I want to just kind of chart process out a little bit. So Jamie, if you don't mind, can you have all your folks turn their screen off? It makes it a whole lot easier to find commissioners that way.
Yes, sir.
Thanks, and I'm not being dismissive. I just want to find the folks that I need to talk to. Okay, so commissioners, I kind of want to maybe sort of gut check where each of us may be before we move into kind of next steps in terms of questions. So let me provide some perspective on kind of where I think I am. First off, there's a lot to like here, no doubt. One operator, 24,000 mineral acres and or surface acres, uncontested. The relevant local government, Weld County, is supportive, which is important to me. The state land board is supportive. That's important as well. The surface owner is supportive, and we heard from him. That's the first Weld County rancher that's come and testified to us in favor of this, which I think is really important. It's, as mentioned, uncontested. The public comments were not from interested parties. They were, sort of folks that are consistent in their desire on, potentially no oil and gas development. It's got a director's recommendation of support. But as I go through my notes, I find a lot of areas in which there are commitments to consider on kind of important issues on a comprehensive area plan, because the comprehensive area plan, again, it's not a permission to operate. It is the intention to develop minerals over 6 years. It allows for fine tuning in the oil and gas development plans for sure. It avoids a patchwork approach to oil and gas development. But some of these areas, and I'm just going to rattle off a few, seems like they could either move from commitment to commit or commitment to consider to either commitment or not commitment. And then we would know what it is we are evaluating. And I'm echoing Commissioner Messner's point that if it's just to consider, then we really have to sort of say it's a no. And the areas that I see are, the work with CPW. They cannot commit today. They agree that a regional plan makes more sense. I mean, that was the last witness that said that, but they don't have it in place yet. I'd also like to talk to Brandon Maret about that. The produced water and piping versus trucks. They are still sort of considering that. There are 4 oil and gas locations. They say they're going to plug them once they get to production, but they've not committed to actually doing that now. The commitment to help staff with the CIDR data as opposed to figuring that out. The commitment to study about electricity and potentially using it for more than just production, but they're not ready on that front either. On the application on air emissions, some BMPs have agreed to, but pursuant to the application, and I quote, still evaluating additional BMPs to further reduce emission estimates, end quote. So I'm in a place where there's a lot to like here. And I think I could get to a place where I would be very comfortable with this as a framework for the development of these minerals in a non-patchworky sort of thing. But right now, for those 6 or 7 areas, and there may be more, I'm happy to go ahead and consider this. And each one of those is a no, because they're not a solid commitment. And if that's the applicant's desire, great. And it may still pass the high watermark in my mind. I'm not sure. So I don't know. That's kind of the place that I'm sort of finding myself. I'm also a little bit confused between the presentation on the, the PowerPoint versus the exhibit 4, which has the BMPs, and I'm a little confused about which ones we're really at now. And I don't want to do that willy-nilly one at a time. And so I think there needs to be some additional effort on that front too. So I think what I'm echoing is that, general support, there's a lot to like here, but perhaps there needs to be some additional spade work. And that spade work can end up with the applicant saying, no, we're not doing these things, and we still think this is approvable, and that's fine. And I guess the final part of my rambling here is, I'd like to hear from the applicant about these musings. They're not planning on filing for OGDPs for 6 months. I don't think this is holding up a rig or anything. So I'm trying to get some sense of timing on that front. So those are my initial thoughts. Because I'm in this sort of spot, I wondered if other commissioners might be in a spot that desires us to sort of talk amongst ourselves before we dive right into questions. I'm done. Commissioner Cross?
Well, I'll start off saying that I think that there is a lot to like here as well. And especially hearing from a surface owner and not having to deal with a lot of the surface issues we might otherwise have to deal with, I think is a huge benefit. I think my biggest questions kind of come to the timing aspect, and I'm happy to elaborate on those, but kind of the idea of how long some of the construction will start, just trying to get some updates on where they are in some of these processes, because there's different dates talking about 18 to 24 months for some pipelines and some of the electrification. And I completely understand where you're coming from in terms of what are they going to commit to, especially when it comes to some of the things like electrification. And I think some of that also goes to a little bit of my questions, what discussions have they had with Excel? Because I can understand completely that it makes sense to continue consideration of what electrification could we do beyond some of the batteries and things like that. But if there's not enough power that can be supplied to this very rural area to power electric rigs, I think that makes sense. And so I think for some of those situations that you're mentioning, not having an answer now, I think is a reasonable expectation. I agree with going over it, and Commissioner Messner mentioned it earlier. Some of them, it's a little bit of wishy-washy language, and I'm happy to go through some of those and trying to better understand what is a commitment and what isn't a commitment on some of these. But I think overall, when we look back at kind of our statement of basis and purpose for Rule 314 and try and understand, the incentivization that we want to give towards caps because it's trying to reduce it. I think for me on the whole, I'm leaning more towards those. There's a lot to like here, especially with what we discussed at the beginning of today's hearing, with a lot of this still is going to be left for the OGDP process. And I think that's because, we are looking at, instead of having, as Ms. Trask mentioned, instead of having numerous operators, I think there's been up to 5 different operators and working interest owners in this area. Instead of having all of them submit separate OGDPs in separate areas and trying to get different things out here, which would cause problems with the surface owner, as we heard in testimony, we're having one operator consolidating all the infrastructure for this, trying to make it all done in an efficient manner. And by doing that and having the capabilities that Kerr-McGee's talked about with some of the reductions and separators, et cetera, we are going to be accomplishing those goals that we have in 314. So I do have some additional questions as well, as I mentioned, especially with respect to some of the timing aspects of it. And I think, Chair, I think it goes back to what you were saying too with, are we going to submit everything within 6 months, even though we have 6 years to do it, and just kind of let it slide after that? And so I think that's one of the things I definitely like to understand a little bit better. But I think overall, the fact that a lot of this is intended to be left to additional and more stringent BMPs and COAs at the OGDP level, I understand where at least some of the considerations as opposed to commitments come from.
Commissioner McGowan.
Thank you, Mr. Chair. I don't necessarily agree with both viewpoints that have been shared. I think I'm more aligned with Commissioner Robbins at this point. I think what I'm struggling with is some of these BMPs that feel a little more like we don't know yet, we're going to try, affect cumulative impacts and how things are being determined as far as emissions are concerned. And we only get one bite at the apple because they don't have to fill out 2 Bs for the OGDPs. And so for me, some of the questions I've had about when do you know whether or not you can electrify, what kind of engines are you going to use? Can you use the Group 3 drilling mud? And for me, it's not odors, it's emissions and volatile organic compounds. They're in a non-attainment area. This is a cap, for me, is attractive because, to your point, Commissioner Cross, one operator, consolidation, a landscape view. But I think the commission offered up some things, no competition, 6 years, don't have to fill out cumulative impacts for each OGDP. There's a pretty big give, I think, that the commission gave in deliberations. My concept was a cap would also be like above and beyond, and showing that because you've got this large area that you are looking at, you really are taking this viewpoint of avoiding, minimizing, mitigating. And I'm not sure that I have enough information up front and a commitment to know what the cumulative impact really looks like for this development. But I agree, you know, it is near a minimum number of sensitive receptors, which I find attractive. I do think that they've thought about trying to minimize the footprint of their development. They're developing all along one corridor and putting all the infrastructure in one corridor. And those are the types of things that I think we envisioned when we were talking about the cap during deliberations, really putting your thoughts together how you are going to minimize your impact. I still am just struggling with some of the cumulative impacts for emissions and some of those things. I'm not sure I feel like there's an absolute commitment from the operator that they're still considering. And I won't pretend like I haven't been struggling with that with individual OGDPs either, but I don't get to revisit this when they submit the OGDP, some of these things. And so I really want to make sure that we understand what the scenario looks like, what this development's going to look like.
Commissioner Ackerman.
Thank you for the opportunity to comment, Mr. Chair. And I would agree with a lot of the sentiments that have been spoken before me. Wanted to make clear that I like the concept of caps. I think it's a great idea. I think the intent of a cap is to evaluate comprehensively the impacts and come up with strategies beforehand to avoid, minimize, and mitigate those impacts. And really, the intent of a cap is to provide a surety of practices and tie it up as much as we can in a nice bow as to what this practice is going to look like over the long run. And there's a lot of benefits to that, and hence, as Commissioner McGowan pointed out, some benefits that are received. I also wanted to state, I echo what you say, Mr. Chair, that I appreciate the significant work and brain power that's gone into this cap. Clearly, there's been a lot of work and a lot of thought. We're poking at some of the parts of it that we have questions about, but I don't want to just pass over that there was a lot of great work done in compiling this cap. I particularly appreciate the landowner coordination, as was demonstrated here today. I think that's a great step forward in the development of large parcels of land. That said, I did also agree that I found parts of the cap to be what I would consider to be underdeveloped for what I had expected, again, to restate what Commissioner McGowan said. I'm particularly concerned about the lack of discussion about the primary mitigative strategy in an HPH for pronghorn, which is winter range timing stipulations. They're absent entirely from the cap as far as any type of discussion as to, even if, you know, we considered this primary mitigative strategy, which is the primary mitigative strategy, and decided against it for reasons A, B, and C, it's instead just absent and not discussed. That's the mitigation strategy that would be asked for in this HPH above all others, and it's not discussed. So that's a glaring absence to me. I would agree with Mr. Reimer that a mitigation plan is appropriate at the cap stage. I think that a comprehensive wildlife plan goes right along hand in hand with a cap to help us understand how the wildlife impacts are going to be avoided, minimized, and or mitigated. And so I would like to see a hand-in-glove approach with regard to that type of a mitigation plan. And then I found that there were bits and pieces that I think certainly could have been further developed. I think most of those have been mentioned here already. I think one that hadn't is the mention of, field verification of wetlands. It sounds like, attachment 4 said there hadn't been any from my read. It sounds like there have been since then. And so to me, part of analyzing the cap and putting together the cap is doing those field verifications and documenting them in the cap as to what exactly exists on the ground. And then, of course, I continue to share the same concerns that have been brought up, just the consideration of produced water takeaway. We've struggled with that at the OGDP level, but I particularly struggle with that at a cap and larger analysis planning level. That said, I do appreciate the commitment to pipelines. I appreciate the commitment to a more inclusive infrastructure and thinking about what infrastructure they'll need and what the timings will look like. So I would agree with you, Mr. Chair, that I certainly can go forward and talk about this cap further today and make a determination based on what's on paper. But I do think, an opportunity to give the applicant an opportunity to cure those things they'd like to cure is appropriate.
Commissioner Messers?
Thank you, Mr. Chair. Thank you, commissioners, for your thoughts. I think caps are an incredible opportunity, and I think that we contemplated them as an opportunity during the mission change rulemaking. I think it was highlighted by Ms. Trask's and AG Davenport's presentations earlier in here, as far as the opportunity to not have patchwork development, to look at things holistically and cumulatively, comprehensively in its approach. I think that's clearly lined out in the first section of Rule 314 as far as what the intent of the cap is. And I want to recognize that I think the applicant has, generally done a really good job of looking at different a location that seems appropriate for a cap, that is looking at things big picture and holistically as far as the size of the operations, and has a lot of important pieces within the cap application that that I think are helpful in evaluating it. I think that there are sections of the application that are really well done. I think that there are other sections of the application that are significantly lacking. It's possible that those sections that are significantly lacking actually meet the minimum standards of the rules as drafted. It's possible that they don't, but it's possible that they do. But I don't think it embraces the intent of the cap, which is really to tell a story of and a narrative about what the intent is comprehensively for a long-term plan for oil and gas activity in a particular area. I think that that's ultimately what the surface owner indicated that he was interested in, and why he's attracted in this particular approach to oil and gas development, is looking at things holistically, centralizing facilities and infrastructure and activity, minimizing truck traffic, making sure that there's no impacts to wildlife. I mean, this is all stuff that came out of Mr. Servy's mouth, and I couldn't agree with him more as far as why a cap is an appropriate tool in this particular situation. And I don't have any reason to believe that the applicant doesn't intend to do all these things. But when I read the application it conflicts in so many different places, even today from the PowerPoint presentation to the Exhibit 4, is realizing that the Exhibit 4 is really what the application is. And so when I'm looking at Exhibit 4 and the BMPs associated with Exhibit 4, that's the application. Well, there's BMPs associated with some of the responses to the CDPHE letter that maybe are incorporated in the Exhibit 4, maybe aren't incorporated in the Exhibit 4. Certainly the entire response or commitment table in the response to the CDPHE letter is not included in Exhibit 4. There are elements in the PowerPoint presentation that are worded slightly different than the BMPs that are associated in Exhibit 4. And so I think that cross-reference needs to be really tight. And I also think that there's different sections in Exhibit 4 itself that say different things than the BMP section. And so I think that there's just a general lack of tightness to some of the information that I think is certainly resolvable. But before I can really consider approval of things, it's important that I know exactly what I am approving. And like Chairman Robbins says, there's certain circumstances where that it's appropriate to say that you're going to consider these things, and that's fine in a lot of circumstances. I think that's just needs to be clear, the areas that are considered and the areas that are shalls, and that there's no question that there's going to be a commitment. And it can't be, I will commit if feasible, or I will commit to the extent possible. It's got to be a pretty straight commitment, so that further down the line, as we look at OGDPs, we can tie these things together. It's going to help the operator with clarity in the future. It's going to help staff with clarity in the future. And so these are the questions that I intend to ask should we continue on with this particular hearing today. I also think there's an opportunity to consider a continuance or a stay for some amount of time certain, to allow perhaps some of that to be addressed by the applicant, and then come back to us for deliberations, questions, and determination. So I can go either way, but I think it may be beneficial to consider a continuance or a stay. I would agree with Commissioner Ackerman that the wildlife piece is huge for me, and to not take the opportunity to really have an in-depth consultation with CPW, in partnership, develop that wildlife mitigation plan at a landscape level that helps guide future OGDPs and infrastructure development even prior to OGDPs, which would be pipeline infrastructure development. I mean, I think all of this is really an important piece of all of this, if not directly tied to the quantitative analysis associated with the cumulative impacts reports within 314 of our rules, still an important consideration through that consultation with CPW, and that wording that says we will work with CPW, which is great. I mean, I think that's a great thing. That's a completely unenforceable and hypothetical terminology associated with that. And I just think that it's important to try to minimize that so that everyone's clear as far as what the expectations are. I feel like I'm talking a lot, so I'm going to stop now.
Commissioner Cross.
And one thing that I think may be helpful as well, I know that earlier it was mentioned that Mr. Moret would be available, and it might be helpful to, especially considering some of the concerns about wildlife, to hear from him as well.
I agree. So I'm just looking at our rule. 314H5 does provide us with the opportunity to determine that additional information or analysis is necessary for it to make a decision to approve or deny a cap. The commission will order a stay, will issue an order staying consideration of the cap for further consideration until the director or operator can provide the commission with additional information or analysis necessary to consider the cap. The commission may set or extend reasonable deadlines for the director or operator to provide additional information or analysis to the commission. I think I'm hearing, I mean, again, And Ms. Jost, if you want to appear, thank you. I want to provide you an opportunity to respond on behalf of the applicant to the thoughts here. Again, I think if I'm sort of looking and listening to my fellow commissioners, there is a great deal of support for this application. And I think you've heard some musings or some thoughts around how that support could be greater developed with maybe some additional work. It also may be your client's position that the amount of work that's been done is sufficient to meet the standards of 314. So rather than me talking, do you want to provide some perspective? Do you want to huddle with your client? I mean, I really want to provide you with whatever you need in terms of direction.
Yeah, and thank you, Chair. I appreciate that. And I do think I'll take an opportunity to address some of the comments as part of this discussion, and then also maybe kind of end up with the fact that I think that there's probably some benefit to walking through some of the specific BMP concerns with the subject matter experts today, because there's only so much that can go on a PowerPoint. There's this application was filed in December last year, so things have evolved and have changed to get to hearing, and that we can address. And then also really want to talk about the process here. I do see that AAG Davenport has appeared though, so maybe I'll let him jump in before I start my kind of response and requests.
AAG Davenport, do you have anything at this point?
I don't have anything specific. And Ms. Jost may address something. I wanted to raise Rule 301E and the director of the commission's ability to request additional information on OGDPs and how that may interplay with Rule 314. But I don't want to anticipate where Ms. Jost is going to go with anything. So please go ahead.
Thank you, AG Davenport. And I guess maybe one thing I would ask before I do continue is, based upon some of the comments from the commissioners, there seems to be maybe a misunderstanding about one bite at the apple versus kind of a process and several bites at the apple. I didn't know if you wanted to address that or you wanted me to address that as part of my response.
It's a little bit of a chicken or the egg thing. So commissioners, to just be very clear about this, as you all know, one of the things the applicant has requested is the right, and Rule 314 does provide this, to not submit a Form 2B cumulative impacts analysis in the course of OGDPs. Is submitted in caps, assuming the cap is approved ultimately. And I think when Commissioner McGowan, you talked about only getting one bite at the apple, that's really what you're referring to. And so I have been taking a look at some of the other rules other than 314 and am aware that Rule 301E, as in egg, does provide that the director or commission may request any information necessary and reasonable to make a final determination on a permit application before the commission. And wondering, that certainly appears to at least contemplate giving the authority that even if there is a cap approval, to request effectively what is a second bite of the apple at cumulative impacts. I would feel more comfortable relying upon that if an applicant, and frankly Kerr-McGee, would agree that staff still had that authority pursuant to 301E to ask for more data about cumulative impacts on an OGDP by OGDP basis for OGDPs within the cap. And so that's why I said it's kind of a chicken or the egg thing with Ms. Jost here, is while I think there is a rule that potentially gives that ability, given 314's provisions, I would recommend that we hear what Kerr-McGee would agree to or be willing to commit to before relying on my interpretation there.
Great, and thank you, Mr. Davenport, on that. Chair, if I may, I have a few points that we want to address basically in response to this conversation, specifically to what AG Davenport just said, Kerr-McGee will agree to allow, basically we agree with the analysis of Mr. Davenport. We understand that Rule 301 applies where there can be additional information requested. We think that applies to Rule 314 as well. And so knowing that this is kind of the first step in the development process of the Bronco cap, and also that is to happen over a certain period of time, if staff believes they have additional or need additional information to address cumulative impacts for each individual OGDP, or even just as the OGDPs are developed through the cap, Kerr-McGee doesn't have a problem with that. And I believe that's what Mr. Picara also stated in his testimony. And we're sorry if that didn't come across as clear as it should have. But we would actually welcome that. We understand that through Sabrina's testimony and Ms. Trask's testimony, that as the staff reviews how the CAP, cumulative impacts data, gets put into the CIDR database and how that's used in its annual report, if the staff ultimately says we need 2 Bs, that is something that would be open to, but for an operator to commit to that today, when the staff hasn't determined what that kind of process is, it's very hard to do in that standpoint. But we don't have any concerns if staff comes back during the OGDP stage and says, we need additional cumulative impacts information. We're happy to provide that. We're willing to provide that. As you know, Kerr-McGee does an insane amount of emissions monitoring and air monitoring, water, soil, terrestrial, wildlife. That's information that we would likely expect to receive requests for additional information on as these OGDPs progress. So maybe on that note, I'll kind of stop there if there's any other questions. If not, I do have some additional comments to state before we get to kind of the specific BMP discussions.
Actually, Commissioner McGowan.
Thank you, Mr. Chair. So I'm just trying to make sure I understand, Ms. Jost. So I think what I hear you saying is when we get to the individual OGDPs, that Kerr-McGee then might have better information about what they're going to commit to. And I'm back to chicken and egg. And Commissioner Cross's comments of sometimes things aren't lined up and you have to wait until you hear from somebody else, like a third party, supplier or whatever. But then I think what I hear you saying is that you're willing, the operator is willing to submit Form 2Bs for the OGDPs in the CAP. I'm not sure that, and maybe you can explain to me what your thoughts are about this. I'm not sure it solves the problem for me of knowing ahead of time if I'm going to get electrification, if I'm going to get Group 3 drilling mud, if I'm going to get pipe produced water until we get to the OGDP. Oh, I'm sorry, Amy. Are you guys hearing an echo? I don't know why it is.
We are. Do you have 2 mics going, Commissioner McGowan?
I do not.
Sound like Darth Vader.
I'll try to exit and get back on. Did you understand my question on this, Jost?
I did, Commissioner, and I'm happy to try to answer it. That's okay. So, when we heard from Ms. Trask this morning, it wasn't clear if it was going to be, do they want additional associated information with the cumulative impacts, or do they want it to be, we understand staff is still trying to figure that out internally. From Kerr-McGee's standpoint is that we will commit to working with the staff that if they request additional information on any OGDP that would house any of the individual Form 2 oil and gas locations, we'll provide that information to the staff. From the standpoint of not having commitments today versus having commitments later, I think there's a couple avenues I'd like to just really address there. Is that first off, with the cumulative impacts analysis that was provided in Exhibit 4, that did present kind of the worst case scenario And so when additional BMPs are added, that would effectively reduce cumulative impacts. And those can be clarified at the OGDP stage. Because as we understand this process and fully recognizing this is the first CAP to go through, so everyone has kind of learned together on this, is that the CAP does provide the landscape level planning and the plan, which is Exhibit 4, that includes, the initial BMPs that were proposed by Kerr-McGee, many of which are committed to, and we understand there's concerns about the electricity, the drilling mud, and a few other things that we would like to address today. But there's also a substantial amount of over 50 BMPs that Kerr-McGee has committed to today to carry through to each and every oil and gas development plan and location within the Survey Ranch. And so we do believe that we're in compliance with Rule 314 as that was intended. We do want to talk to this commission about working through the questions on the BMPs that were listed. I will call it as commit to consider versus just to commit. We understand that was a delineation utilized by Mr. Coffin from CDPHE, and we really appreciated that. We think his letter was very helpful from our standpoint because Kerr-McGee was able to make substantial commitments from that letter. But then in the same vein, we also need to account for, what the CAP was meant to allow, and that is this landscape level planning with significant cumulative impacts analysis. And then there is a next step. And so the commissioners and commission staff, at least from our view, and again, Mr. Davenport, please correct me if I'm wrong here, but we'll have additional bites at the apple, Commissioner McGowan, because those OGDPs still have individual reviews. They have individual reviews on the siting locations, as well as the individual ability for the staff to request additional information for cumulative impacts. And so that's where we're really understanding the CAP rule to be the first step in order to continue the granular discussions at the second step. But in Kerr-McGee's stage, they have put in a lot of commitments to ensure that once we get to that second step, it is those additional kind of more intricate commitments that can be made at the OGDP level while we still work through things with third-party providers, like the electric companies, like the produced water aspect and things along those lines. So maybe I'll stop there and see if that answered your question appropriately. And if not, I'm happy to elaborate.
So I'm gonna assume I still start sounding like Darth Vader. So I think I'm gonna hop off and then hop back on and try again.
Okay.
Hey, Karen, or Commissioner McGowan, why don't you do that? I'm going to hold everything. We're not going to do anything further until you reappear. Just take a minute or two.
Okay. Am I still Darth Vader?
You are not. You are Princess Leia.
All right. Excellent. Thank you for your thoughts. So let me I'll nitpick on the drilling mud because it just seems like low-hanging fruit. Let's just say we have this discussion about the drilling muds and are the emissions better if I use group 3 versus a mixture of group 1, 2 plus water? And I'm not sure I actually got an answer. And let's just say that you all say, no, I don't want to use the group 3. I'm going to use what I'm using, even though it has slightly higher emissions. When we get to the OGDP stage, I feel like the door is closed then for me to say, I really want you to use group 3 because those have lower emissions. Do you agree?
So Commissioner McGowan, thank you so much. And respectfully, I think you do have the ability to continue that request at the OGDP stage. Because again, the CAP is the landscape level planning, including the cumulative impacts. And if you determine that there are concerns with the type of drilling muds that would be used within the CAP lands on those individual OGDPs, from Kerr-McGee's perspective, we do not believe that the door is closed for you to ask for that. And I'm happy again to, once we get past this, to bring on some of the SMEs to really address that VOC question in more detail. But we don't view this as one bite at the apple. And one of the other things I want to just clarify, I guess, for purposes of the cumulative impacts kind of reporting, right now as part of the rule and part of the system, we don't have the ability to submit 2Bs as part of the CAP process. So again, that's a little bit different from the CAP versus the OGDP. And then one of the other aspects would be when we're really looking at this commit to consider BMP kind of line of BMPs, is that those BMPs were requested by CDPHE about 6 months after the application was filed and during our formal consultation. So some of those aspects are relatively new, but they have been evaluated and analyzed enough by COGCC to say, it's not a flat no. We will commit to consider those as part of the OGDP stage, along with any additional information that's requested by the state.
Okay, thank you. I'll tell you something else that I'm struggling with, which I think is a double-edged sword, which is the benefit of turning in or supplying a cumulative impact report or analysis that assumes worst case scenarios that we know then, okay, this would be the most emissions that would come from this activity. The flip side of that is, I'm not sure then that I know how, if you've really minimized or mitigated first or tried to avoid to get the best, I guess, the best product that you've introduced to us. And then I think Ms. Merlin had some pretty good points in her testimony of so the good and the bad is that you all are the first CAP, right? And so we're kind of working our way through this together, and it's a new set of rules. You finally get comfortable with the OGDPs, and now we're like, oh, it's a different animal here, and trying to figure out how this is going to work. And so I appreciate your willingness to have some dialogue as we work through this. But given that you're the first CAP and folks are kind of going to see, well, how did this CAP go? I'm not sure that I want the worst case scenario from all the operators. To Ms. Merlin's point, if you're trying to like compare what the impact is of this CAP versus that CAP versus OGDPs, and some folks are turning in worst case scenario, and some folks are turning in, this is what I can actually commit to. As a commissioner, how am I supposed to kind of figure out if I'm comparing apples to apples, for example? And if you have thoughts about that, I'd be glad to hear, but this has been kind of a difficult thing for me to wrap my head around.
Yeah, and Commissioner McGowan, I guess, Chair, if I may.
Please.
Yeah, and frankly, we struggled with the same thing, right? Because being the first CAP definitely has a pro and a con. One of the things in the analysis here is that, again, we are not asking for preliminary siting. We are asking for the allowance of the CAP to proceed forward on this comprehensive development as we continue to work with stakeholders, the COGCC, CDPHE, CPW. So understanding the aspect of, it's tough to understand how to delineate this and compare it to something, because frankly, we don't have anything to compare it to right now at this point in time under the new rules, under Rule 314. When we're looking at this from kind of the worst case scenario versus what is actually going to happen, that's actually specifically why we included those two slides for avoidance, mitigate, the avoidance and mitigation slides, because we recognize that technically that probably wasn't required by the rule, but we wanted to go that extra step to ensure that the commission understood that we have evaluated those BMPs in the avoid, minimize, and mitigate factors as part of the CAP. So we actually were doing that earlier rather than later in the process, so we could really work with this commission to have you guys understand what went into this evaluation overall. The other aspect of this is that while it may be this kind of worst case scenario, it's also very conservatively calculated, because when you look at where this CAP is, it's not in an urban area. It's in a very rural area where, yes, we have high priority habitat, but the human receptors are not there. And so that does shift the focus a bit to, so what do you do with wildlife? What do you do with air? What do you do with water? You know, in addition to the humans that we're typically used to dealing with on the OGDP level. And so the conservative analysis that's been used is really just to ensure that we thought, you know, thinking we have met the rule 314, really trying to provide that conservative information to the commission for purposes of analysis, with the recognition that this will continue to be a conversation with staff and you as the commission as the OGDPs progress within the CAP boundary.
Okay, thanks. Thank you for all your thoughts.
You're welcome.
I think at this point, you obviously have heard from commissioners. You know, I want to give you, whatever opportunity you desire to bring your subject matter experts in to, respond to these initial thoughts. I didn't do these initial thoughts to sort of, suggest we're going one or another. We're just trying to figure out how to, proceed at this point. So I do note that a stay is, something that's up for consideration. Moving forward with considering approval or denial is certainly, in the hopper this afternoon. But I want to start by just giving you an opportunity to, gather your folks together. And the other point I want to make is, if it would be helpful to you and the applicant to have time to huddle to, gather your thoughts, be that for 10 minutes, 30 minutes until tomorrow morning, whatever is most of productive from you and your client's standpoint.
No, and thank you, Chair. I think that it would be great if we can have about a 20-minute huddle with clients. I mean, we would like to continue the conversation today so we can address some of the BMP questions I think that came up, as well as maybe engage in a discussion specifically with Commissioner Messner and yourself about some of the specific BMPs that you do have concerns with, so we can have the subject matter experts provide some additional light and information on those. So if we could break maybe for about 20 minutes so we can huddle up, that'd be fantastic.
So let's break until 1:40. It's 21 minutes out.
Great, thank you very much.
All right, it is 1:40. Welcome back. We are back live on our continued discussion on the Bronco cap. Ms. Jost, did the 21 minutes provide you sufficient time to chat with your client and be prepared to take whatever steps you want to take?
Yes, absolutely, Chair. And it was a very welcome 20 minutes. We had some really good in-depth conversations and some information I'd like to convey to these commissioners. First off, we understand and really appreciate the conversation about the Group 3 drilling muds, Commissioner McGowan, and Kerr-McGee will agree today to commit to utilizing the Group 3 muds for purposes of any OGDP, as well as any Form 2A within the CAP. Secondarily, they will also agree, and Commissioner Ackerman, this goes to your statements as well as conversations with Brandon Merritt, that Kerr-McGee will commit to getting a comprehensive wildlife mitigation plan in place prior to filing its first OGDP within the CAP. And they will work directly with CPW on that, as well as Mr. Servey on Servey Ranch. And then with respect to the aspects of produced water and electric rigs, we recognize the desires of the commission to have those committed as soon as possible. One of the things we run into is very much a chicken and the egg as well. The produced water takeaway and electric rigs are fully dependent upon third-party commitments and third-party contracts. And where we run into the chicken and the egg is that those third parties typically won't commit until we have an approval of a permit, an OGDP, or in this instance, a CAP. Once it's committed, or once that's approved, that commitment then occurs that we can carry through to the OGDPs. And so again, While we can't commit to produce water takeaway today because of third-party concerns, I guess I would say, and things that are really outside of our control, as well as the electric rigs, we absolutely do agree to continue to progress the produced water takeaway and drilling rigs, electric drilling rigs, as the OGDP process continues. And if this is approved, then that gives Kerr-McGee the ability to go to those third parties and say, hey, look, we have this approval. Let's get those contracts in place. So maybe I'll stop there, but we really appreciate the feedback and the conversation on these, and recognizing again that we anticipated a lot of questions, but with the first round of CAP, it's really hard to anticipate absolutely everything. And so we think that your initial feedback on this has been very helpful. And we hope you can recognize Kerr-McGee's statements that I just provided after your allowance for the 20-minute discussion.
Commissioners, thoughts, feedback to that feedback, to those commitments that we just understood? Commissioner Messner.
Thank you, Mr. Chair. Certainly appreciate those, Ms. Jost, and I think that's good for the applicant and good for the process. I'm just trying to figure out how we capture all of this into Exhibit 4, right? And so this is what I'll continue to be hung up on here a little bit, because this is, for lack of a better word, the controlling document on what those actual BMPs and commitments are. And this is an area where why I asked the question as far as really, having a submittal that clearly lines out, what is firm commitments, what are considerations, and then that can be clearly indicated in Exhibit 4 so that there is no confusion as far as what's what. And I'm happy to give you some examples. So give me just a second here. So number one, I appreciate that you broke down what you were committed to and what you weren't committed to as far as the CDPHE consultation. And I understand why you include in there the commit as feasible in some of those pieces, because it was part of the CDPHE consultation. And so I understand that. However, many of these commitments that you've made in that CDPHE letter, at least for this commissioner, can't be found in any kind of updated Exhibit 4 or any kind of updated application that would be the controlling document, right? So we've got this associated document, but it's not actually in the controlling document. In addition, we've got, just bear with me here a second, I'm going to go a little bit. And so, for example, in your Exhibit 4, Rule 314E3E, which is your plans for electrification, you've got in your application that you'll work with a power provider to do this stuff. But in your CDPHE document, you said you've indicated you will. And I'm not talking about rigs, I'm talking about production facilities, compressor stations, so on and so forth, which is, generally, I think, what you've committed to in the CDPHE document. Another example would be, you've got some BMPs in your Exhibit 4, like your first one, which says during completions, Kerr-McGee uses a closed loop system. There's other places where you've committed to a closed loop system, but then further on in your BMPs within Exhibit 4, it indicates that during flowback and well completions, utilize a closed loop techniques to the maximum extent practicable to minimize emissions. So either you're using a closed loop system or you're not using a closed loop system. This is that like, I guess, inconsistencies that I'm struggling with in a controlling document. You also state in your second BMP in here, to ensure the well-being of those working, living near our operations, we contract with a third party environmental air quality expert to perform continuous air monitoring during drilling completions and during early productions to the extent required. Well, to me, that's not clear, because in other places you're saying that you'll do it for 6 months after the beginning of production. In the controlling document, it just says to the extent required. I mean, I'm happy to go through more of these things, but these are the type of things that I'm talking about, because there's also things that you put in the table of your PowerPoint presentation that are proposed BMPs in the PowerPoint, but they're either slightly different worded in the controlling document, or they're different than in the controlling document, or they're in addition to what's in the controlling document, so would need to go into the controlling document. Does that make sense?
It does, Commissioner Messner, and I really appreciate that feedback. And I agree with where you're going on this with respect to clarity for specifics of the BMPs. So one of the things that, again, just kind of working through the CAP process, and maybe this is part of the rule cleanup that will come, is that the cumulative impacts plan, the Exhibit 4, gets submitted with the application. There was an amended Exhibit 4 submitted prior to completeness. Completeness occurred, and then that Exhibit 4 continued through all of the consultations. And so the consultation that we had with CDPHE and Mr. Richard Coffin that addressed additional BMPs and the commits and commit to considers kind of came after that, and we didn't have the ability to go back and amend Exhibit 4. But I think, you know, what could be done, and if I may ask AAG Davenport to potentially join and weigh in on this, is that to have a delineated table of the BMPs that are committed to, in addition to the table that has commit to consider as part of the final order in this, you know, hopefully requested approval of a CAP, that gets attached to the order, that actually could help, I think, clarify the BMPs that are committed, but also maybe give you a little bit of comfort that as a result of these discussions today, you have that delineation as part of the order, which is, you know, enforceable and governing the CAP. And AAG Davenport, I don't know if you have anything else you want to add to that, but Kerr-McGee would be willing to obviously amend the Exhibit 4 to add any of the additional commitments and clarifications as requested by Commissioner Messner as part of this process.
Well, let me weigh in a little bit here, Ms. Jost. I think Commissioner Messner did a good job of picking, you know, a few examples. I think what I'd like to see is a clean, clear, precise Exhibit 4, and not an Exhibit 4 that was filed at the beginning and then not amendable, and then a PowerPoint that might have like some places where there's some inconsistencies. And again, this is not suggesting that anybody's doing anything nefarious. This is just we're learning the process, right? And so I get back to my notes. I appreciate the concessions on the Group 3 mud, the comprehensive wildlife plan before your first OGDP. I'm appreciative of the water and electricity issue. I see the chicken or egg thing, and I would be comfortable with, you know, at least this commission will be comfortable with allowing that one to remain as is. I think I heard, and I just want to clarify one other point, that with regard to the cumulative impact information, that the client would be agreeable to file a Form 2B if requested by the director at the OGDP stage. Did I hear that correctly? And that way the director doesn't have to always ask for one, but if there is a need for one, she could ask for that.
Yes, Chair, you did hear that correctly. I think, again, because the process has yet to be determined internally at the commission as to how that may work. But if that's the ultimate route that the staff and the director intends to go, or just needs additional information for an OGDP and a specific location within an OGDP, yes, Kerr-McGee would agree to that.
So where at least this commissioner sits at this point is I'm comfortable with where we're at with regard to the application. and the concessions, what I would like to suggest, this is a supposal, suppose we take sort of a straw man vote in terms of where people are at, but continue this to next Wednesday, our next hearing, and allow for the final creation of that Exhibit 4. And then we would, finalize, you would get kind of a thumbs up today, but it's not binding until we all see this. I think it's really super critical. This is the first one. I don't want to sort of wing it a little bit without knowing, where the parties have arrived at with regard to the BMPs. That too would give staff a little bit of a chance to take a look at the revised Exhibit 4 as well. So that's what I would suggest. But I also don't want to get out ahead of anybody's surfboard. And if folks want to continue to talk or ask questions of SMEs, we got all afternoon. So, but that's one suggestion. Commissioner Messner.
Thank you, Mr. Chair. I think it's a good suggestion. I do actually have questions that may also, that I would like answered, and I can ask them next week, but it may be helpful for me to ask some of these questions today to help inform perhaps a revised Exhibit 4, because the examples that I gave were just a couple of examples. There's quite a few more of those. And then I actually have some just legitimate questions, just like, because I got some lack of clarity. Again, I can do those on next Wednesday, or I could do it today, but
I'd prefer we go ahead and knock it out this afternoon. Ms. Jost, are you in agreement?
I am, Chair, and I'm so sorry to jump in, but we agree. In order to have kind of a line of sight specifically for what the concerns are, we would really like to engage in the full discussion today. So we have the ability to go revise Exhibit 4 if that's ultimately where it ends up prior to next week. So we have all of the input from the commissioners. We have everyone here and we're ready.
So before we do that, I'm just looking to Commissioner Cross, Ackerman, and McGowan. Are you guys comfortable with this process that we've sort of outlined here? Commissioner Cross? You're muted, Commissioner Cross.
Sorry about that. I had the additional microphone muted there. Thank you, Chair. And I was going to make 2 points, and the first one was exactly that point. I think it's probably beneficial for us to try and get through all questions and concerns first, so that we can kind of have everything addressed if we were to do this by next week and not have to potentially push it down the road further, and get everything done in one swoop. And I think, and this is maybe more of a deliberation aspect, but I think kind of taking a step back a little bit, aside from sort of the cleanup, and I appreciate the idea of trying to get everything in one clear document so we are on the same page as to what's being committed to, what's being commitment to consideration. I think one question I have for the commissioners is, are there specific rules that you are currently grappling with aside from clarity issues that you're grappling with? Because I think that also might be something that's important to consider, so we have an idea of, additional things that may need to be discussed as well, aside from just clarity points, if there's specific rule considerations that you're grappling with.
Okay, good point. Commissioner Ackerman?
Thanks, I appreciate that. I don't know if that was a question that Commissioner Cross was posing for an answer now, or just for consideration.
And I think it's probably a little bit of both. I don't think if there is something specific that you have a concern with now, I think that's probably important to know. But I think probably before we make any kind of decision today, I think it's probably at least important to have that kind of idea if there's something that beyond clarity that we need resolved.
Thanks for the clarification, Commissioner. Maybe a couple, but I think the one point that I would make along that line is that the purpose of the comprehensive area plan under 314A1 is to facilitate evaluating and addressing cumulative impacts. And I would just state that I think that this plan does quite a good job with evaluating cumulative impacts. I think we have some some significant work in some areas to do with addressing cumulative impacts in order to meet the full measure of a cap here. And so I would agree that a rewrite of Exhibit 4 is in order. And one point of clarification, is the intent, Mr. Chair, to kind of ask the questions, go through the document today and point out what we believe to be deficiencies? Or will there be an opportunity to submit written comments to the applicant? How do you envision that going?
Well, we're making this up as we go. I think I was thinking that we would, spend as much of the afternoon as is necessary to try to exhaust commissioners' questions, comments, etc. So hopefully that we would have all of our issues identified so that we don't have the need for commissioners to pose additional questions. But if that creates heartburn amongst commissioners, we can certainly do both, I suppose.
Thank you, Mr. Chair. No heartburn from me. I just wanted to be sure which road to go down. So thank you.
Okay. Commissioner McGowan, did you want to weigh in on any of this?
No, I'm good working through our questions and comments today. And I think in addition to the Exhibit 4 and BMPs, to Ms. Joe's comment, some things have happened since the application was submitted. So in the original application, there were only 2 well sites that were owned that were going to be considered for P&A, and I heard in the presentation there are now 4 and they will be P&A'd. So I think there's some cleanup that we could do to make sure that by the time we get to the end of this, that those things actually happen. So I recognize that I had a question about also, I think a cleanup thing is the gas lift versus gas lift technology versus electrically driven. It said in the application that Kerr-McGee is evaluating the need, and now it sounds to me like they've actually settled on the electrification instead, I think. And so I think there's some cleanup stuff that we could do to where they were going to consider as part now are seem more solidified to me in the presentation.
Well, then let's do this. And Ms. Jost, provided you're comfortable, why don't we start with Commissioner Messner and let him run through his questions or issues or comments or thoughts, and then we'll give each commissioner the opportunity to do the same. And your folks can listen in, weigh in if you can, and or take notes, etc. Is that fair?
Yes, Chair, that sounds great. And we will have quite a few different SMEs answering specific questions. If it's okay with you, should they come back on camera now?
Yeah.
Okay.
Yeah, that's fine, because I'm going to give each commissioner free roam, so I don't have to find them.
Great. Thank you. Thank you so much. So I'm just going to say to the Kerr-McGee team, if you could all turn your cameras back on. And again, we'll have a variety of folks answering questions, but we will address them accordingly. And I would like to say thank you for taking the time today to walk through these. We think it'll be very beneficial as we continue this process. So thank you.
Commissioner Messner, you're up.
Thank you, Mr. Chair. Again, I'm gonna be a little bit all over the place here, so bear with me. But I'm gonna just start with the BMP summary in the existing Exhibit 4, and I talked about the first 2. The 4th bullet on there is during production, Kerr-McGee uses production facilities that have been designed to eliminate most emission sources. This kind of goes to the root of one of the big questions, and I'm pretty sure I understand where you're at, but it appears to me that you're indicating that all oil and gas, hydrocarbons, will be piped away from the facility off-site out of the cap to a sales line at some point. And that's what I think I am hearing. And you can clarify that in an updated Form 4. It does say in here, oil will be gathered and sent via pipeline to a stabilization facility rather than stored on location where emissions occur. My question there is, I'm not sure what a stabilization facility is versus, other facilities versus going to a sales line, or how these things all tie together. And so that was just a question that I thought could get answered.
Great. Yes, thank you. And we have Carissa Cray from Kerr-McGee who can address that.
I'm Carissa Cray. I'm the air manager. So we thought it was important to distinguish that it was a central oil stabilization facility and that was done in an effort to kind of point out that we're not just moving the emissions to another type of production facility, but the facility that we send it to is a third-party stabilization facility where it's a large midstream type facility where they actually stabilize that oil, pull out the gas, compress it, send it down the pipeline. So it isn't just moving it to a different storage tank further on down the line. And all of that equipment is also electrically driven. So it's a really low emitting facility.
No, that's great. I mean, that's helpful. It was just a little unclear. I mean, I understand that. I think the intent is to have hydrocarbon takeaway. I just wasn't sure if it was, if the stabilization facility was some other facility associated with the CAP that I was unaware of. So.
Yeah, and it's an existing facility already.
And then one other question that I had, and this is around the produced water piece, is, oftentimes we hear that there are some challenges with the produced water as far as additional impacts associated with putting in the pipeline. We've certainly heard that there's always some challenges around that third party being associated with that. Oftentimes in at least local government land use change application processes, there's particularly hearing Ms. Jost indicate that that it's typically after an approval that you get that commitment from that third party. It seems like there's a potential to put something in there that would indicate that, or a letter from a third party that would indicate that upon approval, then we will move forward with that consideration of that produced third water. I'm not suggesting you have to have it or not. It was just a thought there as I was looking at that could create some clarity.
Yeah, and thank you, Commissioner Messner. Recognizing that still kind of remains in the third party's control. I will ask if John Cook has any additional information to provide on that, or any additional aspect of the produced water company's discussions and where they would stand.
Yes, thanks, Ms. Jost. So we have been in negotiations with third-party midstream companies about water takeaway for several months already, and it's expected to take several more months. And so that's why we're just not able to commit to it yet, because we're still working through a lot of different finer points of the contract negotiations. So it's something we're working towards. It's just something that we can't officially commit to yet.
I think that kind of narrative is super good in an application so that it's understood why and how and help tells that story as far as Commissioner Ackerman indicated, how you're going to evaluate and address cumulative impacts. So just a thought there. There is a BMP in here that indicates that fluids will be consolidated and centralized for collection and distribution to minimize impact to wildlife. It's one of the wildlife pieces. This BMP, I assume, would get modified. I mean, any of the wildlife BMPs potentially get modified should there be that wildlife mitigation plan that it appears that you're willing to commit to, which I think is a really good thing. But it was unclear to me in this particular BMP what fluids, where the fluids are, where they would be consolidated and centralized for collection. So it was just some ambiguity in that BMP that seemed to be problematic as far as understanding what the intent was there.
Great, thank you, Commissioner Messner. And with respect to the clarity necessary, we appreciate that feedback. We can clean that up. I'm going to ask Joseph Reimer if he has any additional comments as it ties to the wildlife aspect of that as well.
Yeah, thank you for the question, Commissioner. What that's really getting at is the removal of truck traffic. So the ability to consolidate both our liquids and our gases into pipelines and be able to safely transport those off location, and thus minimizing the need for oil haulers and potentially produced water haulers to access those locations throughout the year. That's what we're really talking about there. The other thing that kind of ties into that is with our IOC, we're also able to monitor those locations remotely throughout the year. And so again, that minimizes that need for that operator to go out there daily, weekly, or monthly, depending on where we're at in the production life cycle. We're just trying to minimize that potential risk of traffic in that area, in that habitat, is really what we're getting at with those BMPs.
Thanks for that. I mean, I certainly understand the intent. I'm kind of diving down on the specificity in the BMPs itself, so there is no confusion for even future commissions as to what was committed to. And then, and I think that again, that wildlife mitigation plan and that consultation and the further analysis, I think will tie into this as well. But, you know, within the BMPs, there are some, well, within the Exhibit 4 in general, there's some narrative in there that indicates that because there's not within 2,000 feet of, you know, any kind of RBUs or certain receptors, that some noise standards may or may not be done, or some lighting standards may or may not be done. But I think that the noise and the light ties into the wildlife mitigation in addition to the RBU and human considerations there. And so just a heads up on that one, that trying to understand clearly on that. And then again, in the BMPs that have been proposed in here, you know, while there's a BMP in here to perform a mitigation and monitoring noise model for the Bronco cap, covering all pads, and will determine compliance and be conducted with, you know, 90 days prior to construction start. It's unclear which construction start we're talking about. Are we talking about pipeline construction start? Are we talking about OGDP construction start? You know, what are we talking about there? And does that actually tie into ultimately what may or may not be BMPs associated with the wildlife mitigation plan that could be proposed? And so that's just a piece there that, again, I thought was a little uncertain. The LED, oh, sorry, you can certainly speak on that if you
I'm
want.
sorry, Commissioner Messner, I just want to make sure I understand the comments. So when you're talking about the noise and lighting aspect of it, understanding that there's no human receptors, are you requesting, or at least just providing a comment, that the noise and lighting aspects and the BMPs be evaluated as part of the comprehensive wildlife mitigation plan?
Well, I think that noise and light is a consideration for wildlife, and it has been in previous OGDP. So it's just more of a heads up there that while it may not be a significant impact to humans or RBUs, that it may be more so in a wildlife mitigation plan. And so whatever BMPs are being proposed probably needs to take both of those things into consideration rather than one or the other.
Excellent. Thank you for that clarification.
Yeah. And this is just a nitpicky thing, but to the extent possible, LED fixtures are used to reduce sky glow. I mean, I appreciate that. That's to me a consideration, not really a BMP. I think it's a good thing, but anytime there's to the extent possible, you know, again, to me, that's for all intents and purposes, it's a no. As far as evaluating an enforceable BMP. And I think this is a good example of how, and just to not pick on you all the time. I mean, I think you have some BMPs in here that, you know, while they may not be enforceable BMPs at this stage, it's an example of how BMPs can be utilized, in a more granular level at the OGDP level in this particular situation. So for example, there's a BMP in here that says, Kerr-McGee will use best management practices to reduce unloading events and to reduce potential odor causing emissions when liquids unloading is necessary. That's pretty broad and probably unenforceable in a BMP at this level, but more specificity, I think, in the OGDP would be appropriate there. And I think that makes sense. There was a question that I had here, and in your presentation, it was, I think you indicated that you had provided one to CDPHE, but at least I maybe missed it in the submittals that I was reading. But as part of air emissions in the cumulative impacts portion of Rule 314, there is a requirement for a qualitative analysis as well as a quantitative analysis of potential public health impacts. I don't know if you feel like the submittal associated with the Exhibit 4 was your qualitative and quantitative analysis, or whether there was another qualitative analysis that was provided that maybe I'm missing.
Yeah, and that's a great question. I'm going to ask Mr. John Picara and William Hess to come on, because they can address the qualitative and quantitative analysis as part of the Exhibit 4, as well as the submission to CDPHE that provided the additional cumulative impacts information. So Mr. Picara and Mr. Hess, I'm going to turn it over to you.
Okay. Thanks, Commissioner Messner. To add a little color around that, following our CDPHE consultation, Mr. Coffin reached out to me and he pointed out that he thought in our Exhibit 4, it was a little lacking as far as that qualitative analysis. So working in cooperation with William, Mr. Hess, we drafted a response to Mr. Coffin. Mr. Coffin and I had some back and forth regarding how OGLA staff would want that handled. I don't know what those conversations entailed as far as, if that would make its way into Exhibit 4 or be handled some other way, but that conversation on how that would become a quote unquote public document would be handled. So if you want details about what that response looked like, I know William could address that, but just a little background on how it came up and how it was handled.
Thank you for that. I mean, just a heads up that I felt that the qualitative analysis was also inadequate or perhaps missing in the Exhibit 4. So if there was going to be a revision and you have done something for CDPHE, that may be important to include in Exhibit 4 as well.
One thing I will add, Commissioner Messner, COGCC was copied with that response, so they're aware of what our response was. And again, I just wasn't privy to the conversations between the CDPHE and OGLA staff, but just wanted to.
It's possible it was in a packet somewhere that I missed as well. So this is why I think it's all important to have it in an Exhibit 4 and in a controlling document so that there's no confusion here, right?
Sure.
I think that's it. I mean, I had a bunch of questions around wildlife and wildlife mitigation and some of that stuff, but I think the commitment to the wildlife mitigation plan, I think, negates some of those questions today until there is a future documentation that I may have questions about.
Questions from commissioners? Commissioner McGowan.
Thank you, Mr. Chair. And I appreciate you trying to answer some of the commissioner questions ahead of time. I think that I need some more explanation of why the emissions in the tables in the exhibit don't decrease over time as wells produce less. And I hear that you're saying, well, we don't have tanks, and so I'm still just not understanding why we wouldn't see fewer emissions over time as a well produces left, regardless of what type of production you are or technology you've implemented. There should just be fewer emissions, I think. So if you could explain that to me, I would appreciate it. I am not getting it.
Absolutely. Thank you, Commissioner McGowan. And Mr. Hess is going to answer that question.
Yes, thank you, Commissioner, for the question. So It is because we're not setting tanks at these facilities. And so once you, well, we're proposing to possibly set water tanks, but once you remove the storage tanks from as an emission source, what you're really left with is things like heaters, maintenance emissions, fugitive leaks and stuff like that. And those are emissions, and the way that get calculated, the calculation methodologies for those are such that they really don't decrease with production, and they're not production dependent. They're more of a steady state. It's more of a steady state year over year emission. So that's why you see emissions stay kind of flat over the production phase once we get out of the drilling phase. And then it's also important to note that we're fully controlled from the beginning. So you're not seeing any shifts in control methodologies year over year until you get towards the end of the cap and we start PAing facilities. I don't know if that's helpful, if you have any follow on, if you want me to go more
Yeah,
detail.
I think it is. I didn't realize that regardless of how much is being produced, that the emissions of kind of what I call the agrarian everyday equipment and its use continues to have the same amount of emissions. It feels very counterintuitive to me, so I appreciate the explanation. I think most of my other questions have already been addressed for now. Thanks.
Further questions? Commissioner Cross?
Thank you, Mr. Chair. And thank you to everyone for answering some of these questions. And I guess my first question will kind of build off what Commissioner McGowan was just asking there. And this might be getting a little too nitpicky, but one of the things I noticed going through the table of the projected cumulative impacts is that you do have obviously the higher emissions during the initial drilling phases, kind of the first couple of years, and then it levels off. And I also understand you're going to have a little bit less emissions once you start to P&A wells towards the very end of the life cycle of the wells. The one question I had, and there's a slight spike in year, I think here it's 29 in some of the emissions. And I'm wondering what the slight spike is from, if that's how that was kind of put into the model.
Yes, I can take that question. So we count emissions from the P&A rig. So when you hook that up to the facility, you're going to have some small amounts of combustion emissions to run that equipment. And since we count that into our maintenance emission bucket for air permitting, we elected to also include those emissions in our cumulative impacts. So that's why the first facility that we PA, which I believe is in year 29, or when you see that spike is from introducing emissions from the P&A rig.
Perfect, thank you. And I appreciate that. And I think it also, that kind of explanation is also helpful because I think it shows, to the extent we are talking about what cumulative impacts you're looking at, it really shows that, okay, we're looking at kind of not only the worst case scenario, but looking at all the additional ins and outs that go into it. And so making sure that we're not kind of missing anything in the modeling. So I think that is important and I appreciate it. I'll start off with, and I indicated this before, I think some of my larger questions were more so trying to understand some of the timing aspects of what was being talked about here. And so, and Ms. Jost, I'm not sure who's probably going to be the best person to talk about this. But one of the things that was put in the exhibit 4 was talking about it would be approximately 6 months before you would file your first OGDP. And then I guess we'll start with from there. It also talked about a quote regular schedule of OGDPs thereon. Does the applicant have an idea of what the regular schedule might entail?
Great, thank you for the question, Commissioner Cross. I'm going to ask Mr. John Cook to address this for you.
Yes, thank you, Commissioner. So you're correct. After approval of the cap, we would start the submission process, the OGDPs, and we expect that within 6 months of approval. We haven't fully decided on what the size of the OGDPs would be yet, and so we're still contemplating how many OGDPs total for the full development. But the plan is that once the first one is submitted, we're going to start working on the second one, and then the third one, if there is 3, we're kind of kicking that around. So it's going to be a kind of a regular cadence, but it's not going to be, there won't be 11 OGDPs, but it'll be kind of larger OGDPs, smaller number, that will just be continuing to progress as we work through the process.
And understanding that it's kind of in development, do you anticipate it being maybe going north to south? So any rig movement would be kind of in a continuous line, so you're not going back and forth throughout the cap boundary as well.
Yes, that's our general expectation, is that we'll kind of, we call it mowing the grass, but we'll basically start at one end of the cap and then kind of work our way down.
Perfect. And I think going along that timing aspect of things as well, it talked about 18 to 24 months for the electric infrastructure after the contract for equipment is signed. Is this what, Ms. Joseph, what you were referring to about you had to have that approval before the electric contract was signed?
That is correct. Yes.
Okay. And similarly, it also talked about approximately 14 months for pipeline construction. Given that you have a surface use agreement, do you have any updates on where you are with respect to the pipeline construction, or is that also being waited on for approval before you begin?
I'm going to ask Mr. John Cook. Is that something you can address as well on the pipeline aspect?
Yes, so that's also similar to like our produced water gathering. So we're still in negotiations with the gathering company, or the midstream companies, on how we're going to gather our oil and gas and water. And so once those negotiations are completed, we still have to file all the relevant permits and stuff. So that's going to take a while for construction to begin.
Okay, so this is a third-party pipeline midstream company, or not one of the subs of Occidental?
Right. And yeah, our SWA does allow for pipelines. It's just we're not at that stage yet where we can start signing those contracts and start construction.
Perfect, that helps. And then I just wanted to make sure that if you are getting ready to submit OGDPs within 6 months of a potential approval of this CAP application, that 18 to 24 months and the 14 months is not going to throw off some of these timelines that you're talking about.
Thank you. And Mr. Cook, can you answer that as well?
Yeah, so the plan is to have all of the infrastructure built before, to the wells before the first well is put on production. And so it's all going to be kind of working in concert with each other on construction, with the OGDP submittals and approvals, trying just to get everything ready for, potentially 2024 spud.
And I think similarly, and this may be getting ahead of things a little bit as you're talking about developing a comprehensive wildlife plan, but do you anticipate that the winter timing steps, given that this is high priority habitat, will be part of what you're going to be discussing as you're kind of planning this moving forward?
Yes, and thank you, Commissioner Cross. I'm going to direct that to Joseph Reimer. Sorry, I tripped over my words there, Mr. Reimer.
Thank you, Ms. Jost. It is Reimer, and thank you for the question, Commissioner. That is something that we've considered throughout the planning process, and we're going to continue to consider that timing limitation as we go forward. And that's what we're working with at this time. It is something that we are reviewing internally currently. I can tell you that, and it is something that we're going to discuss in depth with CPW on Friday as part of our field consultation. So that won't negate the consultations that we'll have at the individual OGDP level. We'll still have to meet that threshold as part of the permitting process, but this is a consultation we wanted to have ahead of time, and again, aid those comprehensive wildlife plan discussions. So hopefully we can develop a better idea of what that timing limitation is, and if we're able to accommodate with that with our plans here in the not too distant future.
I appreciate it. And then I think the last kind of timing related question I have, which again was, I think, a big part of what I was wanting to get an idea of, is especially if the timing steps come into play, and depending on how the OGDP scheduling is going, do you anticipate keeping a rig on site throughout the pendency of all the wells being drilled, or do you anticipate potentially having to rig up and rig down? And if that is the case, is that also considered in your cumulative impacts?
Great, thank you for the question. And Mr. Cook, I believe you can address this.
Yes, our current plan is to have a continuous rig and frac crew in the area. As I said in the presentation, this is a major development area for Kerr-McGee, and so yeah, it's going to be a large part of our development plans in the future.
Thank you. And then I just wanted to, I think one of my questions was answered before with the kind of the discussion of kind of the contracts and the chicken and the egg discussion. So I think my last two questions are with respect to some of the consultations going on. And the first, I'll look at some of the CDPHE consultation. And in the recommendation, it talked about CDPHE wanting to require additional consultation at the OGDP level with respect to cumulative impacts and site-specific BMPs. And I completely understand the BMPs, and I just want to make sure that I'm understanding that the additional cumulative impact analysis that they're hoping to get consultation on is what we're talking about with sort of the 2B issue, making sure that we're drilling down and getting more specific, or is that, do you understand that to be something different?
Great, and thank you for the question. I'm going to turn it over to Mr. Picara.
Thank you, Commissioner. I do see that as a little piece of about probably the BMPs piece, and if we have any more, able to commit, I guess, to some of those other BMPs and how that might affect cumulative impacts. I just don't want to speak for Mr. Coffin on that and misspeak, but I think that's pretty much what it's related to. But our conversations to date have been that we're willing to have any conversations and consult if they would like to further. But regardless, I think we've had great conversations so far, and I just think the open communication is just going to continue regardless. So whether or not it's a formal consultation that CDPHE requests, or if it's just one-off conversations with Mr. Coffin, we'll still continue those as they would like.
Thank you. And then with respect to the CPW consultation, another one of the things I saw said CPW was hoping to get additional consideration of consolidation. And maybe this is more appropriate for Mr. Moret to answer, but do you know what kind of additional consolidation has been discussed? And is that something that is also under consideration?
Great, thank you. And Mr. Reimer, I think you can address this.
Yes, thank you, Commissioner, for the question. So we've kind of had a multi-phase conversation with CPW, or plan to have a multi-phase. So the first consultation was the first time we kind of really showed CPW the cap. And so that was more of a desktop review. And so what we kind of spoke to is the process up until that point, as far as going from, I believe, around 19 locations as initially planned down to those 11 locations that you see before you at the conceptual level. So that was the first kind of conversation we had. We had a little bit of a alternative siting discussion at that time and explained about being able to drill east and west from these centralized locations, being a lot more efficient than maybe spreading out our locations to either side of the cap. As far as further consolidation, one of the things that conversation focused a lot on was a lot of the takeaway pieces that we've discussed here today, and making sure that we're utilizing that primary corridor that exists for both on the power line side, the power line road, and making sure our additional infrastructure follows those lines. The last one that we discussed with CPW at that time is our compressor station is currently conceptually planned very close to a couple of our other conceptual drill locations, and just seeing if we could maybe co-locate those and make that one disturbance area, as opposed to potentially having 3 separate polygons that may be kind of visual at the conceptual level. So those discussions are ongoing. But again, the biggest thing that we've been able to do, or tried to do throughout this planning process, is again centrally consolidate our stuff, all our planned development to that existing right-of-way, whether it be the pipeline, the utilities, the potential produced water takeaway, our traffic, and our physical well locations have all been tried to be centrally located.
And with respect to that additional consolidation that you're talking about, instead of having 3, kind of put it in one location, is that something that you've also talked to Mr. Servi about? I
would look to surface land to get into what is actually in the SUA.
And thank you, Commissioner Cross. Mr. Dave Hartel, you may be able to answer that. And if you need Commissioner Cross to repeat the question, you can go ahead and ask.
Yeah, thank you, Commissioner Cross. Dave Hartel, Rafael. The anticipated reduction, we work strictly with Mr. Servion. If we reduce from, per se, 11 down to a smaller number of pads, we would look to consult Mr. Servion on that, get guidance from that as it is his ranch as we move forward with the reduction of footprint there. Does that help answer your question, sir?
It does, yeah.
Okay, thank you.
Perfect. I think those were my big questions. And I think overall, you know, I know we'll do a little bit more time with deliberations, but I do appreciate the presentation and the commitment to speaking with us and kind of going through some of these questions, because it is difficult with this being the first one. But you know, I do appreciate the efforts to, especially between initial concept, the efforts to further consolidate, the efforts to try and make sure that this is getting an infrastructure that does try to, you know, address those cumulative impacts and lower the impacts and the surface disturbance that we'll have to the greatest extent possible. So with that, I kick it back to the chair.
Thank you, Commissioner Cross. Commissioner Ackerman, did you have anything further at this point?
I sure do. Thank you, Mr. Chair. I will be very brief, though, as my fellow commissioners have addressed most of the points that I had outlined as well. Just wanted to make a couple of points in summary and wanted to reiterate once again what's been said a number of times and what Commissioner Cross just said. Just very much appreciate Kerr-McGee breaking this important ground. And I particularly appreciate that you have so many staff members here and the appropriate staff members to be able to have this conversation so that we can work through this together. And just wanted to once again thank you for your professionalism and for your patience as we continue to work through this first cap. I wanted to reiterate just a couple of points that were already made, but one of those points was really scrubbing this document for conditional language. And if you use conditional language, you know, we'll assume the intent was for it to be conditional. So for example, on page 6, you know, it talks about plans to use, anticipates deploying, evaluating the potential use of, those kinds of points. As I'm prone to say, any may is also a maybe never. And so as a regulator, I have to look at it from that standpoint. So something that I'm hoping is intentional as we go forward. I also wanted to talk just a little bit more about the wildlife plan. I really appreciate the commitment to work on a comprehensive wildlife plan prior to the first OGPD. And wanted to just kind of reiterate a little bit one point. And I appreciate Mr. Reamer's comments, and I apologize for mispronouncing your name before, Mr. Reamer, that will continue to be an evaluation. You know, the mitigation hierarchy as far as wildlife is concerned, particularly in high priority habitat, is first to avoid impacts and then to minimize those impacts. And then if they're not avoidable or minimizable, then to mitigate those impacts. And with regard to high priority habitat for pronghorn, avoidance is generally the best tool. To not drill during those winter timing steps, and that's generally January 1st to the end of April. I understand from what Mr. Reamer said that that's under evaluation, but it will be subject to schedule and availability of equipment. And I do understand that from an industry perspective, you know, there are a lot of moving parts. I do think one of the benefits of having a cap is being able to plan for those moving parts and really do follow that mitigation hierarchy and avoid first when possible. And this is more of a statement for my fellow commissioners than for others that are listening, is that where I begin to be concerned is that when we don't avoid as a matter of industry convenience rather than as a matter of the impact is unavoidable. And so I would ask, as you go through the wildlife plan, to consider that concern, that avoidance is the best tool where possible, and that where you don't avoid, that it, you know, that there's it's not necessarily just for convenience sake. I do continue, to my fellow commissioners, do continue to worry about a potential pay-to-play mitigative scenario, choosing mitigation rather than avoidance. So thank you for letting me talk about that. I also, the last comment I wanted to make with regard to cleanup of the document was I found this largely in the wetlands and water areas, but it did cause me some pause when I saw points that did seem like desktop review rather than field review. But some things were said today that made me understand that there has been further field review since the application. I do appreciate the ongoing field review, and think that it would be nice to update the document with the field reviews that have been done since the application went forward. So with that, I believe all my other points were addressed by my fellow commissioners. And once again, I can't overstate the appreciation that I have for you undertaking a CAP, and for the great work that's been done by this staff, and for the patience and professionalism as we talk about it here today. Thank you.
Thank you, Commissioner Ackerman. I had two questions. One is for our wildlife officer, who I believe has been elevated to the panel, Brandon Moret. Are you with us?
Yes, I am. And for clarification, I'm not a wildlife officer, but a certified wildlife biologist. But thank you, Mr. Chair.
Yes, of course you are. I shouldn't have assumed. Anyway, thank you for being with us. Have you listened to the hearing today?
Yes, I've been on since the beginning, and yes, I've gotten have listened to the entirety of today's extensive discussion. So, and trying to find the right time to chime in. So, appreciate the opportunity.
Yeah, and that's really why I elevated you. I wanted you to have the opportunity to chime in. Do you want to chime in from CPW's perspective or your perspective, given the discussion and kind of where it looks like we're landing?
Absolutely, and I agree with this approach. And I think, as far as, especially since this is the first CAP that's going through, and how I'm foreseeing it, at least for the Northeast region for Colorado Parks and Wildlife, is that that the overall, whether you want to call it a comprehensive wildlife management plan or CAP-wide wildlife mitigation plan, that it would focus on avoidance minimization measures. And that would be roughly 90% of probably what my comments are, whether it is the avoidance of the pronghorn wintering season from January 1st to April 30th, and also other BMPs, whether it is lighting or noise or fencing. That being said, I want to leave the last 10% of the OGDP specific wildlife mitigation plan, which will still have 90% of the avoidance, like Commissioner Ackerman was just talking about, and minimization measures, but the last, 10% for anything new on the landscape, whether it is a new raptor nest or other considerations, if one of the locations goes forward, say 3 years from now. So you want to leave that flexibility, but still understand that there are some overarching wildlife avoidance minimization measures that should span all 11 locations.
Great, thank you. Does any commissioner have any further questions of the witness? Commissioner Cross?
Thank you, Mr. Chair. And Mr. Moret, I think I'd just like to confirm with you that some of the additional consolidation that was being talked about in the director's recommendation was going down from that 19 to 11, and the additional potential consolidation of equipment into one site instead of three, as Mr. Reamer discussed earlier.
Yes and no. I believe when I talked with Mr. Reamer earlier and Mr. Patara, that there's also a couple of sites on the north side that I would like to see further consolidation, and we can discuss that further in the field visit on Friday, which for the record was supposed to happen by now, but circumstances beyond our control has caused that field visit to be rescheduled twice. So that's why we haven't had that discussion yet. But yes, that will be a further point of consideration. That on one hand, like the other commissioners have mentioned, there has been extensive work, and like the landowner, excuse me, and Mr. Service has mentioned, it is CPW's concern. I don't want to minimize the wintering pronghorn on there. And that's my biggest concern, especially during the winter time. And so given that the consolidation of the roads and the pad locations are along a single road, that is a lot better than having, whatever, 20, 30 proposed pad locations on the landscape there, because my biggest concern is fragmentation, and I want to maximize the amount of wintering pronghorn habitat on the landscape. So to the extent possible, to minimize that impact. So, but yeah, we can further discuss those consolidated pad locations on Friday as well.
Thank you.
Great. Thank you, Mr. Moret, for bearing with and being with us all day, and we appreciate your continued work with us. I only have one other question for your panel, Ms. Jost, and this was something that I started with this morning with staff, and it is the hypothetical that you receive a 6-year, right, and then OGDPs that are approved under that 6-year right are also vested for 6 years. And there's a hypothetical that you could obtain an OGDP, say, the fall of 2022 or whatever, but your client decides not to drill it until, 2028 or something like that. And by that point in time, the BMPs will have become potentially stale, or there may be additional best management practices that really are the state of play for operators within the state of Colorado. How do you comfort a commissioner that expresses a concern along those lines, knowing that that's not what the company angles to do? But I'm just, there may be others that are wondering that thought as well.
Yeah, well, thank you, Chair. I think that's a really good question. I think there's a couple of places in the rule we can fall back on to say, as those BMPs and technology evolves, along with new rules that the commission may have as well, that evolution is built into the process for, again, determining site-specific BMPs on OGDPs as they progress under the cap, I guess, kind of number one. Under Rule 314, I believe it's H, any changes to the cap obviously has to come in front of the commission. So you as a commissioner will get a say on any changes that would ultimately come into play under what in this instance would be a updated Exhibit 4 to clarify what those BMPs would be snapshot in time right now in 2022, which could be amended and revised in 2028. So I guess I'll kind of stop there. I don't know if anyone else from the team has a response, but I think your rules allow for your concern and actually address the concern as written.
Anybody else from the team want to weigh in? Okay. Well, I'm not going to let that issue, derail my position on this. I did want to create a record so that if we do need to go back and make some adjustments, we've all talked about it. We all agree that that is the order of play. So with that, I do not have further questions. I think my fellow commissioners did a good job of issue identification. And so I believe I'm going to suggest an order of play at this point of, number one, Ms. Jost, did you and your client and the company receive, from what you can tell, the necessary direction to be able to make an amendment to Exhibit 4?
I believe that we have. We've been taking copious notes, as well as I know we'll have the audio to listen to as well. I think the answer would be yes. I will turn it over to the team here, though. If you have any additional questions or clarifications, this is the time to ask. So if you do, please raise your hand and we can get those questions answered. Chair, it looks like we may be good to go from those question sessions.
We're going to ask that you make the revised Exhibit 4 and file it for enough time for the commissioners to review it, as well as the director. Friday, Monday, do you have a sense of timing?
I guess, not to answer a question with a question, Chair, but are we aiming for the commission hearing next Wednesday?
We are. August 10th.
August 10th, okay.
And I assume you want us to get to the next hearing and not, I mean,
Correct.
we could do more time, but I assumed you wanted the next meeting.
Yes, that would be great. I think that we could, sorry, I'm looking at a chat here now.
I'm sure you're looking at chats.
I believe that, and Mr. Cook and Mr. Picard, please correct me if I'm wrong, but if we had through Monday, I think that would be helpful, but we also want to ensure that the commissioners have enough time to review prior to Wednesday's hearing. So if we did Monday by noon.
Yeah, okay, so let's say Monday by noon, and if you get it in early, you get extra credit, because that gives the commissioners the weekend to review.
Excellent, thank you.
Okay.
Mr. Chair, could we have a red line version and then the clean version so that we can see what's been updated? That would be helpful for me. Thank you.
Great idea, Commissioner McGowan. So directed, Ms. Jost. And then I want to provide, in folks, commissioners weigh in on this, but I wanted to provide to the director and to Ms. Trask with some direction that definitely have your team take a look at the red line and the clean amended Exhibit 4. I don't know that we necessarily need an amended director's recommendation. I'll leave that to your discretionary call. And then if you find one, just let us know about it so that we know to go look for it. And then if not, if you are comfortable and you don't file an amended director's recommendation, please have someone from yourself or your team available so that we can, ask you about it next Wednesday, August 10th. Are the other commissioners comfortable with that direction to the director and our staff? It's trying to not burden you with more work, but if you feel like it would be helpful. Ms. Trask?
Yeah, thank you, Chair Robbins. I just want to make sure I understand. We can expect the revised Exhibit 4 from Kerr-McGee by noon on Monday, the 8th?
Correct.
Okay, and that'll give us, we'll prioritize the review of that. If we do decide to produce any sort of addendum or revised director recommendation, we'll have that done sometime on Tuesday, presumably, but we'll make sure to forward all of any documentation that we do have. We'll make sure to forward to the commissioners and to Kerr-McGee as well.
Okay, that's very good. Go ahead, Ms. Jost.
Thank you, Chair. I just have a question, not really so much to follow up on what Ms. Trask just said. Thank you, Ms. Trask, for that clarification and the timing. But it would be is that once the Exhibit 4 is submitted in red line and clean version, can we expect questions from the commissioners similar to what we received prior to hearing that maybe we could help address at the hearing on Wednesday as well, if there are any additional questions?
We could probably expect said questions if you get it in by Friday.
Okay.
I mean, I'm just being honest about timing, but commissioners, I'll do my best. We'll do our best to get questions ahead of time for sure.
Great. Thank you so much.
Okay. With that, I think I've only got two more procedural matters. One is a motion to continue, but that's not there yet. I'm comfortable in doing some straw man motion with just a thumbs up or to give some direction to the applicant. Are we now in a spot where it's not binding, but provided we get an amended Exhibit 4 and after our review, we're comfortable with it, are we in a spot where we can provide the applicant with kind of a thumbs up that, we think this is approvable? I'm willing to go there, but I don't want to force anybody's hand. So what are you guys' thoughts? Do you want to do a thumbs up straw vote and AG Davenport keep me in line with the law here? Just trying to provide some perspective on kind of where commissioners are sitting. This is not the same place where we were sitting right after the presentations, and that's a good thing. I think we've done a very good job of working through the issues. Really appreciate the applicants' dedication and diligence with this afternoon, as well as staff. So Cal or AG Davenport, can I call for straw man proposal, thought, vote?
Sure, Mr. Chair. I think you can check in on the commissioners on where they are, and if that's through a sort of preliminary straw dog vote, that's fine, just as long as everybody on the call and the public understands it's not binding on any commissioner, and it's just a check-in based on current stats.
And why don't we do it this way? And I'll just go first. Given where we're at, I'm now in a position that, provided the Exhibit 4 is, where we think it needs to be, I will, likely be voting to approve the comprehensive area plan. Does anybody else desire to weigh in at this time? Commissioner Cross?
I think I'm also in a position to be able to vote in approval of it. I think that the application does comply with the Rule 314, and fully understanding that there will be some additional BMPs at the OGDP stage as well. So I would also be in a position to vote in approval.
Commissioner Ackerman?
Thank you, Mr. Chair, for the opportunity to comment. And I just wanted to make the comment that once again, this is our first cap, and really appreciate the work that's being done on it. I understand that it's helping build a roadmap for us, but I also want to state from my perspective that, at least for myself as an individual commissioner, that it's not intended to be precedent setting in any way, that caps are going to be different as we go through each one of them. And so while it does help provide the roadmap, I think we'll have an iterative process with regard to how to develop caps in the future, and appreciate this first opportunity to take a stab at it. That said, I'm very supportive of the concept of caps. I think it's a very responsible way to move towards development. And I also am in favor of forwarding the concept in this specific cap. I do want to state that I'd like to see what that wildlife mitigation plan and stipulations turn out to be. But I'm certainly supportive of the work that's been done, and I'm supportive of moving forward.
Commissioner Messner, then Commissioner McGowan.
Thank you, Mr. Chair. Yeah, again, a lot of appreciation for the applicant to be first in review of the caps. I'm sure they will not make that mistake again, but at the same time, I think that it was a good process that we're going through here. I think generally, conceptually, it's a good area for a cap. There's like it's been said before, a lot of good things about it. I think I'll be looking forward to the refined application. But generally speaking, I mean, I think based on discussions and what I'm anticipating in there, I think that this would be a good location, and I would be in support of it. Ultimately need to see the application, but I appreciate the work that's been done on the cap. I appreciate staff's work on the cap, and I do think caps are a really important tool to be utilized to really look holistically at activities on the ground.
Commissioner McGowan.
Thank you, Mr. Chair. And I agree with everything my fellow commissioners have said. And I'm really looking forward to seeing the language being kind of buttoned up in the exhibit, and hopefully less squishy language. And I know I kind of jokingly talk about Yoda, but he did say it best: do or do not. There is no try. So if you can minimize the places where you're saying, going to try to commit to something, instead, I'm going to do this, and only the places where you're still waiting. So like electrification and the produced water, I understand. Everything else, if we could have some clear language, and make sure then that we're updating things that were kind of still undecided when we read the application. So I think those are the wells that are being P&A'd. I think there was something else. The electrification of the lift, I think. If we could clarify that language, that would be great. And so I agree. I appreciate how this was put together. I think a lot of thought has been put into this. And I know it maybe feels like some nitpickiness here, but to me, the cap is, it is kind of the starting place then for the commissioners as we look at the OGDPs. And I appreciate the conversation with Ms. Jost that I can ask for something else in an OGDP, but I think I'm kind of limited because the cap is the starting place and the operator then still has the opportunity to say no, that wasn't in the cap. And so I don't feel 100% confident about that. So the more that we can commit to in the cap and say, this is what I'm doing to avoid, minimize, mitigate at the starting gate, I think is best for me. And I'm really appreciative of the work that got put in. And I agree, I think this is a pretty good space for us to be looking at a cap. I think this is what the commission was thinking about when we had this discussion. And I appreciate all the work that's been put in, and I look forward to these kind of an update of the application, so to speak, based on the conversation today. So thanks.
Ms. Jost, one last round. Do you have anything else procedurally this afternoon before we continue?
No, Chair, I do not. Thank you.
All right, then I'm looking for a motion to continue docket 2112-00237 to the August 10th weekly commission hearing.
So moved.
Second.
We have a motion and a second. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? All right, this matter is continued to next Wednesday, the 10th. That concludes the business before the commission this afternoon. Do we have a motion to adjourn?
So moved.
Second.
Motion and a second. All those in favor signify by saying aye. Aye.
Aye.
All right. Thank you very much, folks. Great work. We will see you all later, and we will see you and the applicant next Wednesday, Ms. Jost.
Thank you, Chair.